expert body, but we will leave it at that. But if it is accepted, then it binds the state government. And if it is, my lord, then metamorphosed into a rule under Article 309, then the rule, my lord, becomes a compelling obligation. So this, my lord, is the. Now, my lord, may I straight away take your lordships to the rules?
Please.
And before that, my lord, if I may invite your lordship's kind attention just to see the context of the rules, which is, my lord, please see Annexure P1, which is at page 97. It is a part of the Pay Commission's report produced by the state. That would be printed page 97, my lord.
Chapter 10.
Yes, chapter 10. And PDF would be 137. This chapter 10, my Lord Justice Mishra has that. In this chapter, we have discussed 4 of the most important allowances now available to the state government employees and also to some of the non-government employees covered by our terms of reference, namely dearness allowance, medical allowance, house rent allowance, and non-practicing allowance. We have not been able to devote our attention to other allowances, including the so-called special allowances that the state government currently pays to its employees, some of its employees. We propose to deal with these allowances in any of the later volumes of our report. Then, my lord, 10.2. Now we first deal with dearness allowance. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by Pay Commission gets continuously eroded with the passage of time. Thus arises the need for payment of dearness allowance so as to protect this loss. Now, my lord, this is a rationale for dearness allowance. This is not, my lord, disputed by the state. The state does not say that there is no inflation. The state does not suggest that there is no increase in the cost of living. Now, my lord, please come to 10.3. The state government, since the 1st of April 1979, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably, there is a time lag in actual payment, and when the same is paid, the same does not include any arrears. Right now, only one such installment has remained, due which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from 1st March 2009, was sanctioned by Government of India with effect from 1/1/2008. A major grievance of most of the associations of employees has been non-payment of the DA installments in time, as per Government of India's policy. This is payable twice a year, with effect from 1st of January and 1st of July each year. They are also agreed because of non-payment of arrears. As per information available, we find that apart from notionally allowing the pending installments at the time of the pay revision in the years 86 and 98, the actual payment of DA during the years 97 to 2008 has been as under. Then, my lord, 10.6. It is evident from the above that state government sanction of the installments does not follow any definite pattern. It is clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the government with effect from 1st July 2008, and then, these are the critical words, my lord, fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all employees within our terms. Now, my lord, before I show you the rules, there is a notification which explains, my lord, how this pay commission came to be constituted, how it has submitted the report, and how has the government viewed it, and how the rules have been framed. May I show that straight away, my lord? Your lordships will find this is annexure. This is, my lord, annexure P3. Well, there are two memoranda. One of them is numbered as 1691F, and the second one is 1692F. But let's take, my lord, the first one, which is 1691F. That your lordships will find is at printed page 155. That is, my lord, if I may say so, it's the scanned copy. May I take you, my lord, to the better version, the typed version, which is at printed page 162.
Yes.
Subject clarificatory memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Department resolution dated 28 August 2008, the government constituted a pay commission to examine the present structure of pay and conditions of service after taking into account the total package of benefits available to the following categories of employees and to suggest changes which may be desirable and feasible, keeping in view the decisions of the central government on the recommendations of the 6th Central Pay Commission. And now, my lord, after this, your lordships will find over the page 163, just above para 2, the commission submitted its report on the 12th of February 2009 after due consideration of the recommendations of the commission. The governor has been pleased to make the decisions set out in the following paragraphs in respect to the employee under category 1A above. Scales of pay. The government has accepted the recommendation of the commission in respect of running pay bands and grade pay corresponding to each scale of pay without any modification. Now, my lord, the next para is important. The revised pay structure, which has been prescribed by the government, is set out in Schedule 1 to the ROPA Rules 2009 relating to services generally published with the notification 1690F. Then, my lord, the various rules and regulations. And then these have been, my lord, published in the Gazette. Now, here, my lord, your lordships will find, please now just scroll over to the most important part, my lord, which is at printed page 166. 166.
Clause 10.
Clause 10. And the most critical part, my lord, of clause 10 is this. Consequent upon revision of...
Yes.
Sorry.
Yes.
This is 166. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the dearness allowance which a government employee is entitled from time to time since the first day of January 2006, because that is the date of the Central Pay Commission, 1/1/2006, needs to be related to pay in the revised pay structure. Now, my lord, your lordships may kindly see the crucial words are the dearness allowance to which a government employee is entitled from time to time. Since the 1st of January needs to be related to the pay in the revised structure. This is, my lord, in response to my Lord Justice Mishra's question, that how do the three clauses work? Because the word is aggregate first. It is 1 plus 2, on which, my lord, there is 3. Then please see, now this is, my lord, quite important. And this is how, my lord, the rule needs to be looked at. Now we come to the rules. Now please see now, my lord, the rules.
Sorry, 1 minute.
Yes,
The government notification of 23rd of February is the fourth page.
yes. That is that is the next annexure, Manoj, which is 1692F. I'll place that too at this juncture. And this, Manoj, actually, if I may say so, completely buttresses the position of the respondents. Please see, consequent upon the revision of pay scales of government employees, Manoj, that is printed page would be 168. I think there is also a typed copy which has been provided, which is at printed page 170. 170, it's easier on the eyes. The governor is pleased to decide that the full-time state government employees.
That's something else. That's something.
Oh, sorry.
You have to read from.
Oh, I have to read from that, yes. Yes. I'm grateful. Well, please therefore come back to 168. Consequent upon the revision of pay scales of government employees under the provisions of the West Bengal Services Revision of Pay and Allowance Rules 2009, it has become necessary to relate, well, this expression, to relate dearness allowance admissible to a government employee to his basic pay in the revised pay structure in the case he has elected or is deemed to have elected to draw pay in the revised pay structure prescribed under the aforesaid rules. As has been laid down in Rule 12 of the West Bengal Services Revision of Pay and Allowances Rules 2009, that no areas of pay and allowances to which any government employee may be entitled in respect of the period from 1st of January to 2006 to 31st March 2008 shall be paid to the government employee. That dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st of April 2008 only. So, while the revised pay structure would be worked out with effect from 1st of January 2006, but you will get no arrears. And from 1st of April 2008, that is the newly revised pay, you will be entitled to dearness allowance. Accordingly, the governor is pleased to decide that the dearness allowance payable to a government employee with effect from 1st of April 2008 shall be at the following rates. And your lordships will find this 2%, 6%, 9%, 12%, 16% are the percentages given by the central government, although it was with effect from 1/1/2006. So, what is important is that time to time. That is reflected in this very notification itself. 1/4/2009 onwards, it says 16% and it leaves it at that. Now, let us go to the rule, because this really is the subject of interpretation in our case. Please come to the rules. The rules are, they begin annexure P2 at printed page 100. And if your lordship sees,
yes,
in the foreword, which is at printed page 101, it says the West Bengal Services Revision of Pay Allowances Rules 2009. Sorry. That is forward. But it's important to show
Better
page,
better if you read 125.
Yes.
That is the legible one. Yes.
I'm grateful.
Yes.
I'm very grateful, Manoj. The West Bengal Services Revision of Pay and Allowance Rules 2009 and other notifications on revision of pay of police personnel, civil defense personnel, staff and officers of the Public Service Commission, West Bengal, as well as a memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and allied matters have been published in the extraordinary issue of Kolkata Gazette dated 23rd February 2009. Government has also issued orders sanctioning fresh installments of DNS allowance with effect from the 1st of April 2008, my lord, it should be, not 2009. That I think is an error. It's April 2008. So, my lord, now we come to the rules. Let us see the rules.
There is no error because the original one says 2009 only. We really don't know why.
Yes, my lord, but the rule is from 1st of April, as your lordships have seen, 2008. Now, please come to, my lord, printed page 126. Please see 1-2. They shall be deemed to have come into force on the first day of January 2006. That, my lord, coincides with the central government, the 6th pay commission of the central government. Then please now, my lord, come to rule 3. In these rules, unless the context otherwise requires. Now, my lord, nobody has pleaded that there is a context which otherwise requires to depart from these definitions. Please keep that in mind. Now, my lord, the first is existing basic pay. Existing basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increments, if any, but does not include any other type of pay. And then, my lord, we have that expression existing scale. Then we come to existing emoluments. Existing emoluments mean the aggregate of, which is, my lord, it's the total which has to reach an employee. But it has different elements. The first is existing basic pay. That is, my lord, the unrevised pay. Dearness pay appropriate to the basic pay. And dearness allowance appropriate to the basic pay plus dearness pay at index average 536, 1982 is equal to 100. Now, my lord, the use of this word index, my lord, index itself, my lord, it's a Latin expression, it means a pointer. This index is really the pointer. And how do you calculate the dearness allowance? It is with reference to this numerical 536, 1982 is equal to 100. That is, my lord, 100 rupees of 1982 today is you need 536 to draw the value of 100 rupees which you had in 1982. Now, my lord, your lordships will notice, and that there is actually, my lord, a calculation which I made. It is clear, my lord, from all the rates declared by the central government. They have used this formula, and this formula is the other side as well. This formula, my lord, shows that the denominator is always 536. So that figure 536, which your lordship saw, is critical. Please have a look at this. Please see, my lord, please see for a moment column H. We are now talking of April 2008. In April 2008, my lord, the DA given by the central government was 12%. Does your lordship find that in column C?
Yeah.
I'm sorry.
Yes.
It was 12% in April 2008. My lord, we got 2%. Then, my lord, the balance was 10%. Now, my lord, what is the formula for calculation of central government DA rate as reflected in column C? It is 605. That is, my lord, 536 had gone up to 605.
Yes, yes.
This 536, my lord, the AICPI index rose to 605. So, my lord, you divide it by 536. And you also deduct that 100, because 1982 is equal to 100 has already been subsumed. That is how you get, my lord, 12.87. But, my lord, they now forget the decimals. They give it closer to, that is how, my lord, it is done. So each of these, your lordships will find, January 2008, 2009, 22%, and we got 9%, but the calculation in H is 656. Sorry,
No, it's all right.
656 upon 536, keeping in view 100, that comes to 22.39. So that figure, that average index, which says 536 within brackets 1982 is equal to 100, is the factor of calculation at each point of time when the index changes. Now, please see the next one, 727 divided by 536, and again offsetting 100, you get the percentage 35%. 815, again, you get 52%. Then 887, you get 65%. So, there is actually a scientific, it is almost like an actuarial calculation. Please then turn over the page. In January 2013, the figure, becomes 969. That takes you up to 80.78%. Then, in January 2014, it increases up to 1075, so 100.56%. Then January of 2015, it goes up to 1143. That is how it comes to 113%. In January of 2016, it goes to 1210. And so on, your lordships will find the calculations are available right for all the revisions done by the central government using the AI-CPI index. So, this average is done only by the central government. Now, if you look at the structure of the rule with me now, the words are important. Dearness allowance, the crucial word, here is appropriate. That word appropriate means it must be appropriate to the basic pay plus dearness pay at index average 536. So, this index average 536, if 536, undergoes a change, then taking into account 536 as a denominator, you work out the percentage of increase. This, is really the purpose of this particular rule. So, instead of even taking a position that this is an implicit arrangement in the rule, my submission, is that this is explicit because it is A, an aggregate, B, it is appropriate to the revised pay, C, at index average. And that index average, once you say index, it means, that average will move according to a change in 536. And that is why, that para 10, which I showed to your lordship, said time to time. So this, is really the reading of the judgment of the division bench of the High Court. But, there was one other question which arose before the division bench. There were employees, of the government of West Bengal who were governed by the ROPA rules. But fortuitously, some of them, were working at the Bonga Bhavan in Delhi. Some of them were in a youth hostel in Chennai. And, they were being granted actually the dearness allowance exactly on the basis of the central government rates. Now, that was an additional factor for the court to say that this is a case of discrimination because they're governed by the same rules. And there is no difference, there is no intelligible differentia that they should get a higher. But it was taken into account. But it was not the primary reason for applying. The primary reason is that in the very nature of a dearness allowance, if it is meant to offset cost of living increase, the increase in essential commodities, it is done also in a very scientific way by the Bureau of the Labour Ministry. They actually get data from the Ministry of Consumer Affairs every month on every item. And why they apply industrial workers is they take much lesser in terms of that is essentials, basic essentials which are required. But if their prices have gone up, Then, my lord, they take data from all over India and make an adjustment. And this adjustment, my lord, like even today, as we speak of yesterday, my lord, the central government for the festive season, but because the AI CPI index went up, gave, my lord, a 3% increase to the employees. Now, what I'm saying, my lord, is that this is on the basis of understanding that dearness allowance is not a matter of race. Dearness allowance is integral for the real value of a wage. So, my lord, if the real value of a wage has to be protected, of course, my lord, if the state of West Bengal, let us say, had a Mahalanobis formula, a different formula to actually calculate dearness allowance, it's very different. My Lord Justice Mishra asked an extremely critical question yesterday. What was the basis on which you checked? What was the working? The working, my lord, for a good part of time was only the central government's, but it was, my lord, postponed, as your lordships have seen. So, my lord, the issue is, if the rule gives this method of calculation, is it not binding on a state government in terms of the emoluments which have to be available to a government servant? In addition to this, my lord,
Can you provide us an exemplar of an employee working at Bang Bhavan in Delhi or at Chennai being paid DA in terms of the central government rate?
Yes, my lord, I have
An exemplar
yes, yes,
of any employee
yes, yes, my lord, yes.
who is working at
I'll-
Bang Bhavan vis-a-vis the same cadre of employee getting a less amount of DA if he is working in Calcutta.
Exactly. My lord, I'm showing you the chart. I'm I'm deeply grateful. Please come, my lord, to a chart. Yes. Please see, my lord, Annexure CA2, which your lordships will find is at PDF page 895, but it might be printed page 17. It's a part of the counter affidavit of the second respondent. It is an annexure, my lord, CA2. And this has not been disputed. C1.
It's a counter affidavit.
Yes. Of respondent 2, my lord.
It's mine, my lord, and it's not been disputed.
Yes, yes. This chart is extremely useful. I'm taking advantage of the material available for us.
Counter of respond number 2.
Yes, my lord.
Page.
A printed page, my lord, this would be 17. Printed page 17. Annexure C1.
Yes, please.
Now, your lordships will notice that at page 17 is the chart. Chart showing the discrimination of payment of dearness allowance between the state government employees working at Bonga Bhavan, New Delhi, and Youth Hostel, Chennai, and West Bengal state government employees working in the state of West Bengal in connection with ROPA 2009 and 2019. Now, my lord, your lordship sees April 2008 is from when, my lord, we were entitled to a pay. 1st April 2008. We got 2%. Is your lordship able to see that chart? We got 2%. Your lordships recollect that in that notification. My lord, Bongo Bhavan, they applied the central government dearness allowance and gave 12. Similarly, my lord, all the payments which your lordships will see in column number 3 are exactly those of the central government AICPM. Well, this is not even one exemplar. This is continuing from 2008 all the way. Your lordships will find what was it which we got in the last but one column, and what is it, my lord, others who were also governed by the same statutory rules. What did they get? So, my lord, the suggestion by the state that they don't know how to calculate this is not certainly not belong because they are the ones who gave this. Please see 27, 35. They followed strictly, my lord, all the way as your lordships will find, right up to all the way, my lord. I'm now going to take you right up to 2019, December 2019. They got exactly what was available in terms of the calculation of that formula for the central government. So this is the point, my lord. And this is not merely a case of incidental discrimination. This is a case where the same employer, for some of its employees, is making available dearness allowance exactly, my lord, ditto of the central government based on this formula. So, my lord, the point which is being made by Mr. Diwar, that it was static, it became fossilized on the day, my lord, as I said, in any case, the pleadings, my lord, are in fact inconsistent with this. If your lordship see the judgment of Justice Samanto and Justice Tandon, the two learned judges, nowhere, my lord, is there a suggestion that it stood frozen at a point of time, because, my lord, dearness allowance in its very concept is a variable allowance. This is the point.
Is there any separate GO issued by the government of West Bengal in respect of the Bangabhavan employees and
No.
GT employees?
No.
I think there is, my lord, judges.
Oh, has been subject to correction. Page. Annexure 31, my lord, I'm given to understand of the page 31. Please go to page
Of the same volume,
31 of the counter
same counter of R2
of R2, my lord.
page.
It's page 31, my lord. Annexure C2. My lord, this is actually with reference to the ROPA rules of 2019.
Or it continues the same formula.
My lord, I want to make one thing clear. These cases are governed, my lord, with reference to the ROPA rules of 2000 and 2008-9. 2009 rules, my lord, are the issue in this case. But even after the ROPA rules of 2019 came, it's important to see, my lord, this very significant point.
No, this happened for the first time in 2019.
But that is because the 2019 rules, my lord, did away with dearness allowance in the rule. So what they did was they issued this order consequent upon the revision of pay and allowances of state government employees with effect from 1st of January 2020. Under ROPA rules 2019, Governor has been pleased to order that the state government employees posted in New Delhi will draw dearness allowance, house rent allowance, so and so, with effect from dearness allowance at the central government rate. So, my lord, although the new rules abolished dearness allowance, but they followed that same pattern of giving the central government DA in respect of these employees. And, my lord, the 2019 rules are not the subject here today because, my lord, still discussions are going on. The Pay Commission, which dealt with the 2019 rules, my lord, the report was published only 2 months ago. So that is being examined, how to deal with that. Because, my lord, that actually did away with dearness allowance. So notwithstanding dearness allowance disappearing from the 2019 rules, they continued to give, my lord, the central government DA.
Presently, they are not getting DA.
Where, my lord, they were no, now, my lord, now after a period, that is the new rules of 2019, my lord, they were notified in September 2019 with effect from 1/1/2020. With effect from 1/1/2020 for a period of almost 2.5 years, we didn't get any DA. Then, my lord, there has been small driblets of a minuscule percentage which has been given to us as a dearness allowance, which is why, my lord, it is important to state the point that, my lord, this is not gratis. This idea that dearness allowance is something which is
The-
gratuitous,
The,
is
the methodology is the same.
method, exactly,
2006 to 2008,
yes,
nothing was paid.
exactly, exactly.
Again, 2019 to 21,
I'm grateful.
nothing was paid.
Exactly, Manoj, this is the point.
They are saving it
Yes.
like old days money lenders.
And Manoj, I
And the
couldn't,
businessmen
Yes.
use the money to
Yes.
give to others
yes,
for their own business.
Manoj, for 2 years not to pay you from 1st of April 2008 and give you in driblets. That is, Manoj, what was given in 1st of January 2006, you're making available to me in 2008. So, Manoj, this is the real case.
Perhaps you can, point out and let us know.
Yes,
The counter affidavit filed by
responded to.
page 16 and page 31. These are documents of the year 2022
Yes.
and 2020. Is there any document available there on record, or perhaps you can place? As to
Well, may I just search the record and give you a
what transpired?
yes.
We are interested to know between the period 2009 and 2009.
Yes, 2009 up to 19.
That would be. You may not answer immediately.
I'll just yes, certainly, Manoj.
My lords, we do actually have it.
That is reflection.
We know that, but we just want to. Just look into it.
Yes, we'll do that. My lords, we have it.
If you don't have it on record, doesn't matter, you can still give it to us.
Certainly,
It's on
Manoj, we'll
record.
just.
We know that. In 5 minutes, give us 5 minutes.
Certainly.
Yes,
May I have your notes graciously, my lord?
please.
My lord, we found a document. It is, my lord, a part of the additional documents which, my lord, we have located, which is at page 126, R2A 8.
Yes, sir. This flag.
Page 126. Grateful to my colleague.
Please.
This is 6th of May 2009. Upon the ROPA rules having come in. In terms of finance department,
Sorry.
Yes, please. 126.
126, my lord. Printed page.
Just one. Yes, we are.
Yes. This is 6th of May 2009. In terms of Finance Department memo dated 17th August 93, the state government employees posted are eligible for dearness allowance, HRA, and compensatory city allowance in terms of memo dated 14 January 2000 on the existing scale of pay at the rates admissible to the employees of the Government of India. Consequent upon revision of pay and allowances of the state government employees with effect from 1st of January 2006 under the ROPA Rules 2009 as promulgated through notification dated 23rd February 2009, the governor has been pleased to order that the state government employees posted at New Delhi will draw dearness allowance, house rent allowance, and the transport allowance in the corresponding revised pay structure in the following manner. Dearness allowance at the central government rate. Now, my lord, please mark these words. With effect from 1/1/2006, actual payment will be made from 1/4/2008. So, my lord, in respect of these employees, they shifted the goalpost and made it with reference to the central government rate. House rent allowance and so as has been allowed by the Government of India to its employees and so on. Well, this order was noticed by the tribunal, and the tribunal, my lord, records a finding in the judgment that it is an admitted fact that throughout these employees who were in Banga Bhavan and in the youth hostel did receive the DA on that basis.
One query
Yes.
to both Mr. Diwan and me. Now, is this in terms of or under ROPA, or is it in excess of any other power constitution of the city or other power?
Malord,
We just want to know.
yeah, I completely understand. Malord, if the rules occupy the field and their revision of pay has taken place under these rules. So if the revision of pay, Malord, takes place under the rules, it is, Malord, logical. It's a concomitant sequitur that the DNS allowance also must be under those rules.
See the areas.
And please see, Malord, they expressly refer, consequent upon revision and pay allowances of state government employees with effect from 1st of January 2006 under the.
Even the
You read
areas
it.
are according. Even the areas are according.
Yes,
You read it. The question was purposely put to both of you for
yes,
you to respond to. You
yes.
read it.
No, but now, Malord, let me answer that question. Malord, once you have rules,
So according to you,
yes,
there are rules spreading the fee, and therefore the exercise of the power has to be and is in fact under
Not
the rules. That's just
that is the answer. In other words, Malord, there is no residuary executive power which is vested in the governor to either bypass the rule or improve upon the terms and conditions. Malord, that doesn't exist once it is covered by the rule. And Malord, it is also common ground that these employees were in fact governed by the ROPA rules. So we have within the ROPA rules these, Malord, who are clamoring for this determination of DNS allowance, and we have another set who are being granted exactly as per the central government deed. Now, my lord, the point is, this formula, my lord, the reason why I mentioned 3C3, appropriate, the word appropriate means that it is based upon this index. This index, my lord, is a base. 536 is a base, which is why your lordship saw in the chart, in the entire chart, every calculation has 536. So, therefore, my lord,
One more
sorry,
query which comes to
please,
my mind.
please.
That is this page 126 document
Yes.
in exercise of the discretionary power vested with the government under OPA?
My lord, the discretionary power, incidentally, my lord, no, because under the ROPA rules, may I show your lordship's rules 12 and 14, because, my lord, they actually have overriding effect. Because they have overriding effect, you cannot have anything supplement because of rules 12 and 14.
What you're saying is any which way.
Yes,
Any which way.
yes,
This is under OPA.
that's right.
And therefore, section 3, Roman 3 has to be read, the contact in the background and the control.
Now, in other words, my lord, now let me put it the other way. How is it, my lord, for now the state could have said, for them, my lord, they have said that this is a different, they're living in Delhi, they're living in Chennai. But let us look at it differently.
Because the cost of living in these two cities
Yes.
is obviously higher.
Yes.
My lord, let us, that is true, my lord, but then they are state government. But the point is slightly different. The point is, my lord, 3C3 contemplates a determination. That determination, my lord, has also been worked out. What I'm trying to say is, it is not that there was only one way they understood this rule. It is not that they understood this rule only in the way it has been preached to us, namely that it was frozen and I have discretion thereafter to give you what I can and when I can. They, in respect of these employees, in terms of both the working of the formula under 3C3 and the time for which they gave it, this extensive period of time, until, my lord, finally the tribunal said this is discriminatory and the High Court struck it down. My friend said we have not appealed against that portion of that order. Fair enough, but the fact remains, we are looking at a period, my lord, which is up to 31st of December 2019. That period cannot be effaced. The period from 1st of April 2008 to 31/12/2019, which is covered by the ROPA rules of 2009, this persisted right through. And if it persisted right through, it is, my lord, a circumstance to take into account that is it really possible that the state government did not know how to work out, shall we say, the dearness allowance payable. And, my lord, it is also not their case that this dearness allowance which they gave to these employees in Bonga Bhavan and these are not based upon the working of that 530, 539, 536. It is also not their case, my lord. It is not a case that they have adopted a formula, central government, but the point is, at no place, my lord, has the state said that if you calculate appropriately in accordance with the All India Consumer Price Index, IW, the result would be the rate which we have asked for, which was determined by the central government. And, my lord, AICPI, that rate, is a yardstick. It's a norm. But if you embrace that norm, you must abide by that norm. Well, in terms of even, it's not only a matter of good governance, but as a matter of law, if you embrace a norm, as you're holding out, you are stopped from suggesting to the contrary, because there is a rule. And that is why, my lord, this is an obligation under a rule. And since it is an obligation under a rule, it is a statutory obligation compellable by mandamus. Now, my lord, an argument was raised. How can the tribunal do some quick footwork and come to this conclusion and issue these panoply of directions? My lord, really, that was done by the tribunal in respect of, my lord, a vexed question that should they get it twice a year or should they get it once a year? And, my lord, there was silence. There was nothing very clear. They said the way in which even this dearness allowance has been released partakes of an ad hoc and whimsical character. And if it is ad hoc and whimsical, it is important that there should be some norms. Whether it is once a year or twice a year, we suggest it should be twice a year. The Pay Commission said twice a year. The rule, my lord, doesn't forbid twice a year. And, my lord, as a matter of fact, in that document of 23rd of February 2009, your lordships will see they've also given it sometimes when it pleased them, twice a year. So, my lord, this is the point. They cannot be, my lord, surely the arbiters of destiny when it is not only a matter of contract, but, my lord, an employee of the government, it is a matter of status governed by the rules.
Can you,
And, sorry.
sorry to disturb you.
No, my lord. I was just telling my learned friend, I think it's after quite a few years, we've seen two advocates general, eminent advocates general, my lord, sitting and adorning the bench in this court. It's after quite some time, my lord.
Can you show us the language of the central revision of payrolls?
Central revision. Yes, certainly.
ROPA,
Yes.
we may call it central
Yes.
ROPA.
Yes, yes. In
What
fact,
is the language in central ROPA
yes,
vis-a-vis the dearness allowance?
certainly.
Whether they also use this index average of 5%?
Yes, yes. Yes, my lord. In fact,
And whether there is any reference to AICPI in the central rule?
yes, my lord, because even the latest 3%, which was announced yesterday, is based upon, my lord, the AICPI index point moving upwards. And, my lord, it moved actually, my lord, the basis has slightly changed, but it is AICPI.
AICPI is mentioned in the rules itself, or AICPI is mentioned in the notification? Separate
my lord,
notification,
for the
whenever
central government.
DA is given an inquiry.
I'll just verify it, my lord, and then make an accurate statement. But I'm very grateful, my lord, because the central government, my lord, is also a government. It is a government established under the constitution and our federal setup. And, my lord, it also follows a method. Sorry, I'm so sorry. Well, Lord, I'm deeply grateful to my Lord Justice Mishra. We have the rule, my Lord. I'll just hand over copies of it. This is, my Lord, the Central Civil Services Revised Pay Rules of 2016.
You have copies?
Yes, my Lord. We're just getting it, my Lord. My Lord, this expression, existing emoluments, occurs even in these.
Index provided?
Yes, yes.
Can we just read?
Yes, yes, my Lord.
Can we borrow your laptop?
My Lord, may I read out first?
Can we just borrow it?
Please, please. Existing emoluments, and your lordships will find.
Is it paramaterial? I presume?
Parimaterial, my Lord, it has an index average.
No, but this denominator at index average 536 is not mentioned.
Which one, my Lord? But that is because, my Lord, this index average is this AI CPI, IW average.
Yes. As of
Over 2016, please. I have actually brought the earlier rules, which are the 2008 rules, my Lord. In that, your lordships will find it expressly refers to the index average 536. I'm grateful to my president.
Index average depends on the period when it is considered.
Yes, it is put out.
That's
So because this narrows down to
Completely.
consideration
Yes.
whether AICPI is only a method of calculation or AICPI itself is central DA.
I'm deeply obliged. I'm deeply obliged.
Whether we
Yes.
understand the word AICPI to mean central DA, the rate of central DA.
Yes, it happens
Central
not to be
rate
the
of
same.
central DA.
Because if you work on that formula,
Yes.
you will get at the same.
Because the language is the same.
Yes, yes, yes.
They say, according to the West Bengal government,
Yes,
this definition of existing emolument
that's right.
excludes application of AICPI,
That's right.
according to them.
Which is why I wanted to show you what this rule itself. This rule is identical. So, my Lord, what this implies
Now, be
is,
ready, you have to answer this.
yes. So, my Lord, what needs to be understood is that this is therefore, my Lord, an evolving. Look, when we say index,
You have not developed your case.
which one?
You have not developed your case like this.
No.
You means your.
My Lord, I must say,
when it comes from the code, we have to answer.
my Lord,
Our
with
terms
respect, my
comes
Lord, I'm obliged. To be very honest and, my Lord, to be candid, I did not think through this point. I'm obliged. I'm being honest, my Lord.
No, just it's a way of thinking. It may not be.
No, but
fully
no, no,
applicable.
but the important point is, which your lordships asked me, is that what is AICPI and is this index, this average indexing? That's my Lord, this word, both average and indexation, they have meanings.
Then now comes the question:
Yes,
where is this enabling provision or
Yes.
enabling instructions available with any government to calculate the DA basing on AICPI?
my Lord, that is because this 536, which your lordship see, is actually only from AICPI. My Lord, let me explain this a little. This AICPI, my Lord, is an exercise undertaken, it is not, my Lord, to a private agency. It is undertaken by the central government itself in its two departments, my Lord, of Consumer Affairs and Labour. And what they do, my Lord, is this. They apply, my Lord, different bands. But for industrial workers, that is the basis, my Lord, for this revision of DNS allowance. And, my Lord, what they do is that they calculate and then they calculate what is the extent of variation. And if the variation is substantial, it's not that, my Lord, they don't sometimes give it immediately after a little increase. There might be a gap between one increase and another increase. So what they do is they actually give this percentage based upon these indices. So, my lord, this All India Consumer Price Index, the ascertainment of this average index is a governmental function. And at this moment, it is being performed by the central government. In some of the cases which my learned friend referred to, which deal with industrial disputes, well, there are some references to dearness allowance, but government servants, my lord, are bound in some sense by a determination of a formula by the central government because it is an all India. Now, I am not saying, my lord, for a moment that they could not have come up with another, if I may say so, rational formula. But if they choose to adopt the central government, and which is what your lordship saw, they have been doing since 1979 in the Pay Commission's report. So consistency demands that you come in alignment with it. That is what the Pay Commission recommended. So for the state government today to say that it is frozen, and after which I will only give, your lordship asked again, the critical question, tell us what basis did you work? Where did you get the rates from? If you decided to give 2%, where did you get 2% from? 5% from? Well, there is no suggestion in any affidavit that they did some independent work for the purpose of ascertaining the consumer price index, way West Bengal, and they came to different conclusions, and their statistics were different, and they formed a model. That is not their case. This 536, well, they also acknowledge that this is All India Consumer Price Index. Well, they say, which is why your lordship saw in that note of Mr. Divan, item number 11 yesterday, he admits that this is the All India Consumer Price Index. Then, my lord, the word index, my lord, in the very nature, clearly shows it is a pointer. It is an indicator. It is like a formula. In fact, my lord, that word is now used in computer algorithmic. But it is an indicator. And why does it use the word average, my lord? Because this average of 536 was for all the 12 months which preceded that 536. So, my lord, they take a weighted average of the entire year. And that is that final figure which your lordship see in that column. So, my lord, the question is 536 within brackets 1982 is equal to 100? Does it not furnish a clear mathematical formula? That is the point. If it does, it is a formula, it is exact, it is precise. Well, it is not left to discretion. It is a precise way of calculating it. And, my lord, it is not suggested that dearness allowance is not for the purpose of offsetting cost of inflation. It is also not suggested that this formula, if worked as a formula of indexation, then in that case, you will arrive at proper mathematical percentages, my lord, as we have shown in that chart. And, my lord, it is not that they could not use or prepare this chart. Please take this. It is not that, my lord, they were not aware of this chart, because it was on this chart, on the basis of this calculation, they, my lord, gave those employees this particular rate. So, my lord, this is, if I may say so, the summum bonum as far as the case is concerned. Now, my lord, as far as the legal position is concerned, my lord, there were some judgments which were cited. I first want to just sum up, my lord, the principles. The first is, my lord, a report of a pay commission is entitled to wait. However, it is not binding as a matter of law on a state government. Third, my lord, the government has got discretion to accept it in part or in total, or, my lord, even reject it. It is entirely up to the state government. My lord, to that extent, the prerogative of the government, I'm not questioning. But now, the next question is, if you do have a pay commission report and you accept the recommendations and you frame rules, then in that case, and that crucial words, my lord, time to time, dearness allowance from time to time, clearly means, my lord, that this is an average index which will be moving once 536 changes its position, that number, but with reference to 536 as a base, you will calculate dearness allowance. Now, my lord, the law is if there is a rule, your lordships have said, if there is a rule and the rule obliges you to pay arrears, and my lord, one must also take into account that dearness allowance revision affects not only serving employees, it affects pensions. And that is another factor, my lord, which is why it has to be in the form of a concrete rule. The last point is, my lord, when you have a clear-cut rule, then I submit any reliance upon grace or any reliance upon discretion or any reliance even upon what is, my lord, being pleaded as financial, my lord, no government is truly impecunious, if I may say so, my lord. It would be a contradiction in terms. It would be a contradiction of the very idea of sovereign governments. But suffice it to say, well, these are matters which they have to find solutions. Well, these are matters for which they need to find solutions. But it is not, my lord, open then to the government, and your lordships have held, and my lord, there are judgments in various cases, your lordships have said, that this financial liability is an oft stated argument and is liable to be rejected when it comes to, my lord, enforcement of a rule of obligations which are imposed by law. My lord, this is the gamut of my submission. I will make sure that, my lord, our written submission is updated so that, my lord, it is presented. My lord, if there's any question your lordships wish to ask, I'll be more than grateful.
The decision.
Yes, my lord, I have put it in the note, but your lordships may take it. I summed it up, my lord. I don't want to read extracts of this. I know, my lord.
See, that constitution
Yes.
bench judgment of
Yes.
Mr. Haber.
Which one, my lord?
MP judgment,
Yes.
1956.
1954. That's right, my lord. Yes, Mandava. Let us look at that, my lord.
Yes.
I wanted to show that. In fact,
If you come to Mandava,
there is actually a sentence which helps me, my lord. Let me show.
121, compilation, page 121.
Yes, my lord. I'm just. Yes, my lord. Please look at this judgment. Well, on this judgment, if your lordships will kindly see the para which was relied on, please come, my lord, to paragraph 4. At this would be, my lord, printed page 974, but it is in the compilation. Please see that paragraph 4.
Yes.
On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restrictions which the Secretary of State and Council may by order impose upon the powers of the Governor General and Council or the Governor General and Council, as the case may be, and to the general rule that the amount of a compensatory allowance should be regulated, that the allowance is not on the whole a source of profit to the recipient, a local government may grant such allowance to any government servant under its control and may make rules prescribing their amounts and conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant dearness allowance, and if so, how much. That being so, the prayer for mandamus is clearly misconceived, as that could be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Well, these are the crucial words. According to me, there is a duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of dearness allowance. It imposes no duty on the state to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such a power. Nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. Then, my lord, thereafter, it is on this basis that they proceeded. My lord, the rule is actually for a very different purpose. This is in respect of local government. It is in respect of compensatory allowance. There are words which signify discretion. But, my lord, the learned judge is conscious that if it is a duty, then it goes out of the domain of discretion. My lord, if it is a duty, then it is no longer the subject of any discretion. Incident, sorry, so sorry.
You can.
Please, no,
continue.
my lord, no, welcome.
Please enlighten us. If you come to para 3 of the report,
Yes, certainly, my lord,
what
certainly.
was the
Yes,
list before the High Court?
Yes.
What the High Court has held and what was argued in Supreme Court
yes,
and what is the decision of the Supreme Court?
I'm
Come to
obliged.
para 3.
Yes, yes,
Come
my
to
lord,
para
please.
3 and then answer
I understand.
how do we
Read that para. I appreciate. It's perfectly, my lord.
Yes.
Please see para 3.
and exactly equate your case vis-a-vis
Yes,
Banga Bhavan employees
yes,
with the argument and the case which was before the High Court in para 3.
very well, my lord. Please see. In the petition, it was alleged that the state government should have uniformly adopted the Government of India rates for all its servants and the discrimination in making the twofold slab and accepting the Government of India rates for one slab, that is for servants receiving salary over rupees 400, and not accepting them in respect of the other slab, that is of servants below rupees 400, is highly discriminatory. That the state government has a right to be treated, state government servant has a right to be treated equally with the central government similarly situated, and that every servant has these fundamental and natural rights, and the petitioner and the members of the Ministerial Services Association have a right to demand from the respondent the dearness allowance at the Government of India rates. The petitioner then prayed that declaring that all ministerial servants are entitled to the Government of India rates, the state government should be directed by a writ of mandamus or any other suitable writ of direction to cancel the discriminatory rules of dearness allowance and adopt the Government of India rates to all servants without discrimination, or in any case to provide with adequate rates of dearness allowance sufficient to provide reasonable subsistence for them. The government contested the petition on the grounds, firstly, that the claim for dearness allowance was not justiciable, and secondly, that the difference in the scales of dearness allowance adopted by the Commission and by the committee did not violate Article 14. The learned judges, Chief Justice Sinha and Bhatt, held that under the rules, dearness allowance was placed on the same footing as pay, and the claim relating thereto was therefore justiciable, and that the differentiation made between the employees of the central government and of the state government in the matter of grant of dearness allowance rested on no intelligible and reasonable basis, and that the resolution dated 16 September 48 was therefore banned. They accordingly issued a direction to the state government that they do reconsider the question of dearness allowance payable to the employees concerned. It is against this judgment that the present appeal has been preferred by the state government on a certificate granted under Article 132(1). And para 4 also.
Now, with this
Yes.
principle in para
Yes,
4,
yes.
they have allowed the appeal.
Correct. Now, my lord, please keep one thing in mind. In para 4, it is argued on behalf of the appellant that the grant of dearness allowance is a matter ex gratia and not justiciable, and that neither a writ of mandamus nor any direction could be issued with reference thereto. Now, my lord, there are two answers to what my lord, the Honorable Justice Mishra put to me. Let me apply, my lord, that Bang Bhavan and this. But, my lord, that is a case where we are two people under the same government. The important thing I want your lordships to appreciate is we are not claiming, my lord, the A on a principle of parity with central government employees. This is very important, my lord.
No, you see, but the destination
Yes,
which you want to reach
Yes.
is the same.
Well, that is,
only by way of process of interpretation,
yes.
you is compelling the court or praying before the court to issue a writ of mandamus.
Well, may I say,
I am not
understand.
blaming the central DA
Yes,
by applying this AICPI
yes,
without mentioning that give us central DPI, central DA rate.
Yes.
You are saying apply AICPI.
yes.
But it boils down to the same thing.
Well, the result, as your lordship said, the destination, if I may say so with respect.
The only argument which can save you is that we are not playing anything over and above what the rules say.
What the rule says.
That is what your argument
Yes.
is.
And
And if the rules permit this, then it is an enforceable thing. We are not demanding anything new.
well, not only this,
Yes.
if I may say so, the fact that this coincides with the rate of the central government is not, my lord, the fulcrum of the claim. In other words, my lord, if I claim parity with another person because I say we perform the same functions, then all the judgments which Mr. Divan cited would all become applicable. I am saying that this is only a matter, this is the outcome. But the outcome, the process of the outcome is the rule. In other words, my lord, the fact that I reached that destination does not mean that I actually, through an invidious process of reasoning, I'm claiming similarity. For instance, my lord, let's look at the revised pay structure. The revised pay structure of a central government employee, my lord, is different from the revised pay structure of a state government employee. But, my lord, only for DA, this formula is there because it is only a percentage of basic pay which is given, my lord, as an allowance. Therefore, my lord, I am saying, and my lord, this is a judgment in 54. In fact, Justice Madan's judgment in Central Inland Water Revenue, my lord, it's a classic judgment where the learned judge expounds on what we expect from a state in relation to its employees. Well, it's a lodestar. And the learned judge also says that we must not lose sight of the fact that employees, this doctrine of pleasure, fortunately, over the years, we have put some degrees of constraints in it. But otherwise, the hire and fire, or, shall we say, the erstwhile Henry VIII clause, that, is no longer possible under our constitutional scheme. So, even though we have a federal structure, but if under 309, rules of 30, proviso to 309, they are, in fact, this is the only provision where it is subject to an act of legislature. So, until the legislature passes an act, this is law which actually operates. And because it is law which operates, therefore, rights and obligations have to be determined in accordance with that law. And I appreciate my lord's comment that we arrive at that destination. But, my lord, that destination, if I may say so, works differently for both of us. It is only for the percentage we are the same. We are the same. But, my lord, it is a percentage of the basic pay, the revised pay. That is not an either. That is the point I make. So what is actually worth is only the percentage. And this, my lord, is a part of the expression emoluments. The reason why I'm very grateful, my lord, to my Lord Justice Mishra, as I said, my lord, I really I didn't think of the central government rules, but those rules clearly indicate in 2000, at that period, my lord, they clearly define existing emoluments with reference to this wage. So, my lord, this, if I may say so, is the farthest I think, my lord, I can see.
Do you have that notification by the central government?
Yes.
Sanctioning BA by applying AICPI?
Well, we just,
It is not in the rules.
We have the state government notification.
no, but we also have
Central.
the central ones.
Yes.
Give it to us. Give it to us.
Oh, my lord, it is in the rule itself, my lord, that your lordship wants to see the notification.
Because rule doesn't say the word AICPI is not referred in the rules.
Malord, this is index average. Malord, may I just explain?
Index average.
This index average,
Index average and AICPI is one and the same.
one
Correct.
and the same. Malord, there is nowhere, nothing else.
There is nothing else.
Same language as.
It is the same language, Malord. AICPI is
There is only one index average.
only one index average, Malord, throughout the country.
Mr. Diwan has given a document yesterday explaining what ASPI is.
Column.
Yes. Yes.
Is there any notification to that effect is what we are asking? If it is so, you can give it to us after.
Yes. Malord, in fact, Malord, Malord, there are many notifications of the Ministry of Labour.
Just one.
Yes. Oh, yes, certainly. Certainly, Malord, I'll produce that notification, how this is calculated. And Malord, there's also a third ministry, I forgot, the Bureau of Statistics. Even that is involved in working out, Malord, these indices. But your lordships may take it. I'll produce the relevant notifications from the Government of India website in relation to AICPI and how it is. But your lordships may take it that this index, Malord, that is why throughout, even in the writ petition by the state, they took the position you are getting the Q of this All India Consumer Price Index only because of this Roman 3. That state government also.
In their note, he has mentioned.
Yes.
In their note.
Yes, in para 11. That's right. It expressly mentions.
They have referred.
So, Malord, this AICPI is the only way this indexation happens as far as central government and the pay commissions are concerned.
Is this?
Yes, Malord, in the 2-page note.
11.
The parallel.
Para
The
11.
AICPI index rates are alien to ROPA 2009, save and except only for the definition of a component of existing emoluments in rule. Yes. Existing emoluments in rule 31C3. My lord, existing, my learned friend is referring to in present time. My lord, existing emoluments means that the emoluments which shall exist under the ROPA rules.
That means alien, yet not alien.
Yet, that's exactly the point. Alien, but not fully alien.
Fully alien.
That's the point.
Yes.
And that, I think, Malord, is with respect a contradiction in terms.
Thank you.
I'm very grateful, Malord, extremely grateful. Very kind.
May I just supplement very brief?
No, you, please, all of you this side, we are in no rush.
Yes.
Please take as much time as you.
Because it is not going to be concluded in 5 minutes.
No, not in 5 minutes.
He will also argue.
Yes. So,
Each
From the principal responding.
one minute. We told you, sir, that everyone this side will have a turn. So whichever, whoso.
kindly allow me.
You'll have your say, sir.
I won't take more than half an hour.
You may take as much time, there is no rush, we told you already.
It's so great.
But don't repeat us.
No repetition, Lord. Since your lordship is interpreting the concept of dearness allowance and dearness pay, just 2 paras from one judgment, and then I come straight to the point, on which your lordships were debating just when my friend Mr. Subramaniam concluded. The compilation which they had given, please, the second judgment of the compilation, Bengal Chemical and Pharmaceutical Works, page 49. Please see that. Para 17 onwards. 4 paras I want to read, because that will indicate and perhaps may show some light on the way your lordship will interpret Rule 3.
Yes.
Page 55, para 17. 4 paras only I will read. Before we deal with the contentions of the learned council, it will be desirable to refer to a few decisions of this court, laying down the principles that have to be borne in mind when a claim for dearness allowance or revision of dearness allowance is considered. So these are the principles which have been laid down. In so-and-so versus Calcutta tramways, it was observed. We can now take it as settled that in matters of grant of dearness allowance, except to the very lowest class of manual laborers, whose income is just sufficient to keep body and soul together, it is impolitic and unwise to neutralize the entire race by cost of living in the cost of living by dearness allowance, more so in the case of middle class. So the concept of dearness allowance, because pays are fixed, this dearness allowance in its very basis is something which keeps on increasing, because the purpose of giving this to an employee is to neutralize the rise in the cost of living. Please see the next judgment, how your lordships have further explained. As pointed out in the Workmen of Hindustan Motors versus Hindustan Motors, the whole purpose of dearness allowance being to neutralize a portion of the increase in the cost of living, it should ordinarily be on a sliding scale and provide for an increase on raise in cost of living and decrease on a fall in cost of living. I pause here. It can happen, my lord, if inflation ceases and we go in, in fact, we go in the reverse direction. When the formula is worked, it may even reduce. It is hypothetically possible, though practically never so as in the world we live in today. But the issue I'm wanting to flag is, one, it is to neutralize a portion of the increase in cost of living and should ordinarily be on a sliding scale to provide for an increase in the rise of cost of living. Your lordship can leave para 19, come to para 20. In Ahmedabad Mill Owners Association, it has been emphasized that in trying to recognize and give effect to the demand of a fair wage, including payment of dearness allowance to provide for adequate neutralization, industrial adjudication must always take into account the problem of additional burden which the wage structure would impose upon the employer, and ask itself whether employer can reasonably be called upon to bear the burden. In Kamini Metals, it has been noted that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is always a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Now your lordships is crystallizing what your lordships full neutralization is not normally given except to the very lowest class of employee. The purpose of dearness allowance being to neutralize a portion of the increase in cost of living, it should ordinarily be on a sliding scale and provide for an increase on the rise in the cost of living and decrease on fall in the cost of living. This is what I wanted to point out. So when your lordship will interpret this rule, this is the principle which your lordship would keep in mind, that the whole concept of dearness allowance abhors the notion of fixed allowance, because the whole concept and purpose being to offset the increase in cost of living and therefore sliding scale is the normal notion as your lordships have understood, not today, but from the very time when this concept was brought in. Now, with this background, my lord, now kindly see Rule 3. I have 4 points on Rule 3 to make to your lordships. I can start immediately after lunch because then it will be one.
How much time?
Half an hour, my lord, because I'm not going to repeat what my learned friend said. Half an hour. I just want to read some parts of the original CAT and the first High Court judgment. And yes.
I'll be half an hour after that one.
So whatever time left for me.
No, you have all the time. We'll carry it out.
I will not take that after this argument, not more than 20 minutes.
So, anyone else who's to argue this side? So we move from the premise that today this side would conclude.
Yes.
We move, and then tomorrow.
After Mr. Patwalia, will that I shall take up and.
My lord,
No difficulty. Even if you are not concluding today, we continue tomorrow. But we are just letting them know that tomorrow the hearing would begin. We would continue. That's all. Thank you.
Good.
Kindly allow me to deposit the directed amount in registry. I'm late by 1 day. I have to deposit on 5th and today is 6th. Kindly allow me to deposit today.
Which matter, ma'am?
The matter number is 3179 of 2025. My lauder's order is of 21st July. This time will be tendered yesterday, my lord. Much obliged. Much obliged.
So, my lord,
My lords, before Mr. Patwalia starts, it has fallen for my lords
Mr.
that
Patwalia, are you frowning?
no, I'm not.
You are frowning?
No. I'm only concentrating.
Okay. But with a smile.
Yes.
So, my lords, it had fallen from my lords that something from the central government that connects the AICPI to the dearness allowance. And we have the annual report of the Labour Bureau that creates the AICPI that does so in detail. So, when my turn begins, I will place that.
No problem, I told you already.
Yes.
Gotcha. Rest of the board to be discharged. Rest of the board to be discharged.
Yes, our apologies, we had made it yesterday, clear yesterday though, but not today. I don't think so, the council may wait in the other matters. We'll continue.
Rest of the board will discharge.
That's it.
So, my lord, so far as the central government rules are concerned, we have got them, my lord. I can pass on the copy. Identical provision. Absolutely identical. Just pass on 2 copies. On the second page is Rule 3, which gives the definitions, and Rule 3, Sub-Rule 3.
Just 1 minute. Yes.
It's Rule 3, Sub-Rule 3. Existing emoluments means the sum of 1I is existing basic pay, dearness pay appropriate to the basic pay, and this is a fixed amount. Your lordship knows when the pay commission revise, it is basic pay and then dearness pay. Sometimes now it is called grade pay, whatever. And then dearness allowance, which is a newer concept, which is dearness allowance appropriate to the basic pay plus dearness pay at average index 536, base year 82 is 100.
Parameter.
Exactly this. So now your lordship may just come to the rule.
Yes.
So because it is exactly the same, I may just add one more sentence here. Yearly calculation on quantum therefore necessarily has to be the same. If our argument is accepted, then yearly calculation of quantum has to be made by the state government and yearly quantum is made by the central government. So because the formula of computing the quantum is the same, the percentage will always remain the same. Therefore, this saying that through the back door we are asking parity, that's not a correct way of putting it. There is no back door here. When the rule is implemented in the way we are propagating it should be implemented, as against their static argument, which actually is a very bright one, which has arisen right here before your lordships today for the first time after so many rounds earlier. But anyway, so if it is to be calculated as they have been doing it, they did it up to 2009, as we said it is correctly to be done, as the High Court says in the first round, which I will very briefly show a few paragraphs, and therefore the percentage will have to remain the same. It is not our saying, please give us parity. When the formula of calculation is identical, the parity has to follow with the central government on percentage. Then what is our problem? Really, our problem is the frequency. Apart from overcoming this new argument, which is now of static, the problem throughout actually in this litigation has been of frequency. The central government religiously revises it twice a year. actually, really speaking, if somebody has to have a literal operation of the rule, it must happen every month. But that's not feasible because index is revised every month. That's not feasible. So central government is doing it twice a year. The state government initially for some time did it, then started doing it once, then used to have gap years, not even once, and then ultimately a full stop. So therefore, this parity that through the back door you are claiming parity is actually an argument which is a red herring. The equation, the equivalence on quantum is on the operation of the rule. And our problem only really was on frequency. The government was not giving it because they said we have money, finance. That's what they said, which has been rejected throughout. And I'll cite one or two judgments. Now the question is on interpretation of the rule or on addressing the argument of this static argument. Now please have the rule. I have 3 points on that, my lord. Very quickly I will make them and then show those earlier orders. The rule your lordship can have from the type version of the rule, my lord, which is at page 127.
Yes.
It's read many times, my lord. One more time. I will just read it quickly.
As many times as you want, sir.
Because ultimately, my lord, this will what is going to decide the fate of all of us and also the state government in that way. So dearness allowance, your lordship is got it, appropriate to basic pay plus pay at index average. Now, what is index average? I will not say. I am going to read 3 paragraphs of the note Mr. Diwan gave on behalf of the state government. Please have that note. Because that answers the static argument completely. That note, clause 3, 4, and 5.
Yes.
Now, please have clause 1 and 2 also I'll read all. AICPI is an abbreviation of All India Consumer Price Index. Sometimes it is also called CPI. Somewhere your lordship will see it as CPI only. So AICPI is an abbreviation for All India Consumer Price Index. This index is published by the Labour Bureau Shimla, which is under the Ministry of Labour and Employment. Now, next 2 are very crucial for my argument. The Labour Bureau revises the index average twice a year on 1st January and 1st June. So therefore, index average is well known to everybody when the expression is used in a pay revision rule. And when that expression is used to calculate a dearness pay, which is a concept to offset inflation and compensate to some extent for inflationary trend, then it is the Labour Bureau revises index twice a year on 1st January. The broad purpose of this index is to enable adjustment with respect to inflation. So therefore, I say, my lord, this index average with 82 as the base year in itself is obvious to the person framing the rule and obvious to the person who is to be the beneficiary of this rule that this index average is an average which is revised from period to period, and 536 with 82 as base year, as my learned senior friend, my lord, Mr. Subramaniam showed your lordship, that is the denominator. Because when it increases, for example, if 536 becomes, say, 750, then what is to be the increase in my pay? So then because 536 is the constant, we divide 750 by 536 and multiply by 100. That's how we take out a percentage. I mean, I had forgotten from my 10 plus 10th days, but now I have relearned it. That's how we work out the percent. What do we say? 5%, 2%, 8%. What is that figure? That figure is this index average divided by 536 multiplied by 100. So my lord, therefore they never raised this argument. It is so obvious that we are actually trying to meet a situation which on one side is so obvious and clear, and the proof of the pudding is in the eating. How have you been implementing it? You have been implementing it the way we have been saying it. What is then our problem? Our problem is the frequency of the implementation. Our problem is not that you wrongly understood it, but today, when you want to implement and you are faced with a huge amount according to you, then you want to wriggle out of it. And therefore, this kind of an argument is now brought up by saying it is static. The submission is why I started with that judgment. Static is just opposed to the concept of dearness pay. A dearness pay can never be static. Otherwise, it is not dearness pay at all. Then it becomes a DA or a grade pay or a pay scale. Dearness pay, and it's not, I am not saying it, therefore, it is that judgment of your lordships where your lordships have explained the concept. And in the first round judgment, this is the way it has been put to grant it to us. The tribunal in the first round declined it to us, saying no right. This is the way it has been put to grant it to us. They filed a review which got rejected and the judgment became final. There was no further challenge. So, my lord, at least between them and us, they are bound by that interpretation, if nothing else. That is, according to me, my weakest submission against them, that they are bound by it. It is a submission. I am raising it that they are bound by it. But according to me, it is my weakest submission. Because the very concept of dearness pay, the very concept of index average, the very purpose of mentioning 536 with 82 base year, and the way you have worked on it, are clear pointers that you were never in doubt that it was not a constant. So, my lord, this is one which I am saying. Then, so the index average I have explained, mention of 82 by 100 is my second point. My third point is that this argument of static is abhorrent to the very concept. That's my third point. And my fourth point on this issue is that your conduct, that's my last point on this interpretation of the rule. Now, my lord, just see with me the first round judgment, because was there ever in doubt that it is not static and it is constant? That goes with the first round, my lord. Just very few paragraphs I want to read from that first round judgment. That is P25. It starts at page 368. At 369, please have page 369, para 3.1.
Yes.
Para 2, the original application was filed by the applicants before the learned tribunal seeking following reliefs. A direction upon the respondent to forthwith release 50% dearness allowance, which is due in January 2006, immediately within 1 month. Direction to immediately comply with the report and recommendations of the 5th Pay Commission. I can leave the rest. Now, please have para 3, the first part of it. The learned tribunal arrived at the following finding at the time of dismissing the application. Payment of dearness allowance to the employees of West Bengal was absolute prerogative falling within the discretionary domain of the employer, and infraction and refusal on the part cannot result in denial of accrued right of an employee for getting dearness allowance. Though part of the recommendation of the 5th Pay Commission might have been acted upon, it did not entail that as a necessary corollary, the same had to be carried to its logical conclusion. And the third was the issue of discrimination. So the tribunal held no vested right, their discretion to grant or not to grant. Then, my lord, your lordship may have page 375. These are, your lordship may only note these paras 24, 2 and 25. The argument of the state that it is the above submission para 24 made on behalf of the petitioners and are vividly opposed by Mr. Kishore Datta, learned Advocate General. According to him, the finding of the tribunal was that claim of dearness allowance was not based on any legally enforceable right. According to him, pre-revised scale of pay employee has been transformed from band scale so-and-so. According to learned Advocate General, after an initial fixation, no formula exists for fixation of DA to the employees for subsequent period, etc. Then how the court considers it? Your lordship may come to page 377, para 31.
Yes.
Before entering into the issues involved in this petition, it will be profitable to recollect settled principles of law relating to relationship between government and its employees, public servants, right of government to get remuneration, introduction of the concept of dearness allowance to government employees, and mode of performance of function. Then, my lord, relationship between employees is discussed. I need not take your lordship's time on that. Page 379, right of government employees to get remuneration is discussed. Then, my lord, introduction of dearness allowance to the government employees starts from para 38. Kindly see the opening line of para 42. 43 is what I will rely on. 42. Dearness allowance was introduced to meet increase in cost of living, which was initially known as food allowance. It is a peculiar concept to India, Ceylon, Pakistan, Bangladesh. While dealing with the concept of dearness allowance, then Hindustan Lever is already cited on the next page, that underlined portion. Basically, the concept of dearness allowance was designed to combat inflation, to protect real wages, and therefore it should appear there should be cent percent neutralization. This is a concept peculiar to India, Ceylon, Pakistan. Now, para 43 is the finding of the court that after introduction of variable dearness allowance, the allowance comes at a revisional rate at periodic intervals for the central government employees and state government employees. The change rate is calculated after taking into consideration the increase or decrease in consumer price index. This is a finding recorded after hearing both of us in a judgment which is final inter partes. Beyond this is exactly what they are now trying to resile out of. So if I can just read this para again, Lord. After introduction of variable dearness allowance, the allowance comes at a revisional rate at periodic interval for central government employee and state government employee. How can he argue today static? The change rate is calculated taking into consideration increase or decrease in consumer price index. This is exactly what we are saying. And this is the finding in a judgment inter partes and a detailed judgment. You went in review, you failed. Now, my lord, moving forward, my lord, your lordship may come to page 383. They have dealt with, my lord, para 47 regarding recommendations of the pay commission, etc. I need not read it now, my lord, your lordship would see it. Then 383, whether the claim of employees serving under the government of West Bengal for dearness allowance is a legally enforceable right. The discussion starts from para 50, 53, 54. The rules are discussed in 55. I want to refer to para 59 to your lordship.
Yes.
From the provisions of Rule 12 of ROPA Rules 2009, read with the contents of para 10 of the clarificatory memorandum dated February 23, 2009, and those of paras 2 and 3 of memorandum dated February 23, 2009. My learned senior Mr. Subramaniam showed both. One was general, saying that we have accepted the recommendations of the pay commission and revised in terms of 3. And the second was the variable allowance given up to 2009. In the middle, both issued, I'm reading para 59, fourth line from the top, both issued by the government of West Bengal Finance Department. There is no doubt that the government of West Bengal accepted dearness allowance basically as a component of pay, which is fixed percentage of basic pay, on the recommendations of the 5th Pay Commission, dated so and so, aimed at hedging impact of inflation. Variable. These last 5 words are very crucial. Aimed at hedging the impact of inflation. The learned tribunal did not consider the issue involved in the original application from the above angle at the time of coming to the erroneous conclusion that payment of dearness allowance was an absolute prerogative falling within the discretionary domain of the employer, and action and or refusal on the part of the former cannot result in denial of DA as it is not an accrued right. So they say the tribunal was wrong to say it is their prerogative and getting DA is not an accrued right. And the conclusion after noticing those two judgments is para 65 at 388 at the bottom. Therefore, as a consequence, once the government of West Bengal accepts the recommendations of the 5th Pay Commission for payment of dearness allowance to the extent as indicated above, it confers a legally enforceable rights on the employees to get dearness allowance. So therefore, this is the conclusion which is there, my lord. Then, my lord, on one more paragraph, just kindly have para 69 at the bottom of page 389. Para 3 of the aforesaid memorandum dated February 23, para 69 at the bottom. Paragraph 3 of the aforesaid memorandum dated February 23, 2009, providing for rate of dearness allowance per month on the basic pay of an employee serving under the government of West Bengal for the purpose from April 1, 2008 and onwards, that is the extent to which the government of West Bengal accepted the recommendations till 2009, leaving the calculation for the subsequent period for its future consideration at a rate on the basis of acceptable guidelines. So it was accepted, and therefore, my lord, the writ petition is therefore allowed. The only point which is sent back is, if your lordship will see page 394, para 84.
Yes.
As a consequence, the order impugned in the writ petition stands quashed and set aside, remanding back to the tribunal for adjudication of the aforesaid two issues. One, whether the claim of employees serving under the government of West Bengal for DNS allowance at rate equivalent to the employees of the central government, and whether there is discrimination between the Bangla employees, etc. Now, my lord, this sending back, whether the claim is at a rate equivalent to the central government, also misses the crucial point that rate is nobody's discretion. The rate is the CPI index. Only frequency is the discretion. If you have to give it, you have to work the rule. The rule tells you how you have to calculate on any particular year. Therefore, the tribunal's judgment, which was read copiously, will reject it as equivalent to central government employees, but say you do it at the rate which they are getting, because the rule is identical. You have to get the same amount. So, my lord, therefore, this whole impression created as if we are getting through the back door what we can't get through the front door is completely a red herring. There are only two components of DA: the rate, whether it is fixed or variable, and the frequency, when we have to get it.
No, Mr. Patalia.
Yes.
See, let us read 84 again.
Yes. As a consequence, the order impugned in this
Just on point number 1, they had decided in your favor. Then what is the need for them to remand?
because the working.
Don't say working.
Yes, yes. Only on.
Because their working is not to be done by CAT. Working is to be done by the government.
Let me read 82. I should have read 82 also to answer this question. In view of the discussion and observations, because that was only conclusion, the rationale is here. In view of the discussion and observations made here and above, I sum up as follows. The claim of the employees serving under the government of West Bengal for dearness allowance is based on legally enforceable right, as all employees serving under the government of West Bengal, up to such extent of recommendations of the 5th Pay Commission, which have been accepted by the government of West Bengal by virtue of provisions of Sub-Rule 1 of Rule 12 of ROPA rules, read with Para 10 of the clarificatory memorandum dated February 23, 2009, issued so-and-so, in the matter of drawal of dearness allowance in the revised pay scale issued by the government. So first finding is, employees serving under West Bengal's claim for DA is based on a legally enforceable right. That is one point which is finished.
No difference.
Second, the claim of the employees under the government of West Bengal to get DA at the rate equivalent. So that's what I'm saying. Only the rate was in issue now. At the rate equivalent to the employees of the central government requires adjudication upon consideration of the relevant material. Here I say the crucial point was missed because the central government rules were never put alongside the state government rules, and we are grateful for your lordship for asking for them. The rate is on the rules. The rule will prescribe the rate. It is nobody's discretion. Now, what is the discretion? The discretion only is whether it has to be given twice, once, or as the government says, we will not give it at all. Now, so therefore, all that was left to be adjudicated was the claim of the employees serving under the West Bengal to get DA at a rate equivalent to the employees. Only rate was in issue. And the third issue, the claim of employees serving under the government of West Bengal for DNS allowance at rate equivalent to the employees discharging their functions in Bangla Bhavan, New Delhi, and Youth Hostel at Chennai. So we had twofold argument. After succeeding that we have a legally justifiable right to get DA, we said now my second point is I must get it at par with central government. And my alternate point is, in any case, I must get it because my Bangla colleagues working in those two bhavans are also getting it. Now the tribunal rejects both these points, does not grant either. But what does the tribunal say? Tribunal says you work it out. But the working, what I am submitting before your lordship is the flexibility in working is not there. It has to be as per the rule. The rule gives the formula. And because the central government rule is the same and my rule is the same, necessarily the conclusion has to be the same. When we divide the API index by 536 and multiply it by 100, whether the state government does it or the central government does it, the answer remains the same.
Can you read now para 84?
Yes. As a consequence, the order impugned in the writ petition stands quashed and set aside, remanding the matter back to the tribunal for adjudication of the aforesaid two issues, namely one.
Slowly, two
issues, namely
whether
the claim of employees serving under the government of West Bengal for dearness allowance at a rate equivalent to employees of central government, and two, whether discrimination in the matter of pay of dearness allowance to employees of West Bengal with their counterparts serving in Bangla Bhavan and Youth Hostel, Chennai, on merits without being influenced by the other. So, my lord, the current division bench, which has been read before your lordship, also crystallizes this position that our right to get it has already been finalized, and I am not touching that judgment. That is final. All that I am now going to discuss is the second 2 points, whether we are to get it at par with the central government at the rate of the central government, and second, that Bangla Bhavan. Now, my lord, the cat. All right. Now, my lord, kindly see the judgment of the tribunal in this round. It starts at page 462. Just kindly come to first page 476, where the discussion starts. Just 2 paras here also, not much.
Yes.
Page?
Page 476. Five minutes.
Yes.
Now, my lord, I will be brief, my lord. I'll give the paras in a written note, but I just want to read 2 paras. Now, we would like to consider the first issue, whether employees of government of West Bengal are entitled to get DA at the rate employees of central government. Now, this is the first issue. Now, para 26 in this is very, very crucial. At page 477, because there are some admissions recorded of the government council by the tribunal. Now, just kindly see that at para 26.
Yes.
The question crops in our mind, what norms or principles were adopted by the state government for, I'm sorry, yes, she was noting I started.
Yes, continue.
All right. Para 26. The question crops in our mind, what norms or principles were adopted by the state government for payment of DA along with basic pay in the revised pay structure in terms of ROPA rules 2009. The admitted position is that the state government has released DA at 125% of basic pay with effect from January 1, 19. On our specific query to Mr. Basu, he was the government counsel,
yes,
as to what norms, principles were followed by the state government for payment of DA to its employees, he has categorically submitted that the state government has released installments of DA for its employees on ad hoc basis, depending on financial capacity of the state government. Now, these installments of DA which were being released on every year were not the same. They were enhanced installments. That chart is given at the bottom, 2, 6, 9, 12, 16%. So this static business is nowhere in the picture. This has only come now. because, so, my lord, I mean, so what norms and principles were followed by the state? He has categorically submitted that the state government release installment of DA for its employees on ad hoc basis, depending on financial capacity of the state. Similarly, on our specific query to Mr. Basu, what pattern was followed by the state government for release of DA at 16% of basic pay from April 1, 2009? He has fairly submitted state government has followed the pattern of the central government for release of DA. But here comes my submission that the pattern has to remain the same, because the calculation of percentage is the same in both the rules. He has fairly submitted that the state government has followed the pattern of the central government for release of installment of DA. The installment of DA released by the state government for its employees from 1st January, so and so, and central government can be shown in the following table. Now please see para 27, first line. There is no doubt that payment of DA to the government employees stems from the need to protect the erosion in the real value of basic salary on account of inflation in the market. Naturally, DA admissible to government employees correlated to the level of inflation. Then the last line of this para, be that as it may, fourth last from the end. The government of West Bengal has released DA from time to time by following the pattern of release of DA by the central government, though the state government has released installment at different rates and from subsequent dates after release of DA by the central government. So, my lord, what I'm trying to make out of this is, it was never static. When they released it, they knew it has to be linked to the price index. That is how it was being released. But the frequency was erratic, and that was our problem. So therefore, my lord, sometimes they would change the frequency also, because the government kept on going up gradually. So the government DA kept on increasing, but they sometimes gave less increase, because if you don't do it at a regular frequency and you give gaps, then that leeway to go up and down accrues, because you have not reached that level of the central government. Then after 10 years, suddenly they gave 125, which the central government is giving for the last 10 years. But that doesn't solve our problem, because if we don't get it for 9 years in a gradual increase and only get the increased one for 1 year, that's hardly a small percent. Our gap is for those 9 years we haven't got. And therefore, that is what the tribunal says at page 482, para 30 and 484, para 34.
But the remand was only for rate, not about frequency.
But
the High Court says, read again the operative part of the High Court order when it was.
Yes. So rate will include the frequency, my lord, is my submission. The rate, if the rate, central government, if the rate has to be.
You said that the real problem is frequency, not the rate.
Correct.
But the High Court, while remitting back, says rate.
Correct.
Not about frequency.
No, rate of central government, parity. The remand was on parity.
Yes.
Rate of central, the word uses rate of para 84.
Not parity on frequency.
No, but
parity on rate.
Rate will include frequency also, both. Because central government gives twice a year.
How you are changing the goal?
No, I'm not. If we get parity with the central government, both accrue to us. Whatever central government gives has to accrue to us. So, and even otherwise, my lord, the point I'm trying to make is that when your lordship looks at what is dearness allowance, what is the purpose of allowance, any interpretation which your lordship gives has to be consistent to achieve that purpose. If the purpose is to defeat inflation, then at least this static will not come in. And if it is linked to a consumer price index, which is being modified and improved on a yearly basis, then necessarily yearly basis is the intention. As your lordship said, this is about the rights of an employee. In this case, financial resources, what your lordship wants to do, whether you can, assuming I am to succeed, there are 2 judgments, my lord, I'll cite those paragraphs and leave it there, where your lordships have said that when we are considering financial constraints, when we are considering financial constraints for an industrial employer, or we consider financial constraints for a body or a corporation under Article 12, or we consider financial constraints for a state or central government itself, our parameters are slightly different, because central government has power to generate revenue. An industrial employer or a state under Article 12 may not have capacity to generate the revenue. So therefore, your lordships have said, for central government, the financial argument is normally not an argument which your lordship easily accept. And in cases your lordship have said, it can be in installments, the payments, that we are open to that also. I will cite those judgments or not in a small written note for your lordships. But what?
Yes.
Yes, just kindly have this table at 478. Yes, I'm coming. Just get a passport.
I was only, we were having a small discussion, nothing to do with.
No, that's very healthy.
So I was telling my lord that depends on state to state. You said that states don't have money. Lord comes from a state where there's surplus money. Jharkhand, you
Correct.
said surplus money.
Correct.
Not surplus, but comfortable.
But I was saying that
Himachal is not comfortable.
Both of
being a first generation state, 76% of the budget of the annual budget goes towards salaries.
Correct.
There's no money for development.
Correct. Even that way, Himachal is, I think, deficient at the moment, and so is the state I come from, which is very unfortunate that Punjab is deficient, but that's how it is. Now, if your lordship will see, the problem is only, just see this table also which they gave.
Yes.
Now, just see this table at 78. The rate 2% is given by the central government in July 6. State government gives it in April 4. Then when they revise it, they don't revise it for almost 1 year. And the rate is 6, but the state government gives it in June 8, central government in January 7. Then again, when the revision takes place, central government does it in November 8. Here they have done it earlier. Then 12/9, state gives it in 8. So they are lagging behind. And then they completely stop. It becomes blank. So therefore, my lord, therefore ultimately the submission is, my lord, that in fact the ACPI index is built in. Static is an argument is not valid. And ultimately in the first round, the finding that we are to get it and that it cannot be static and it is correlated to the ACPI index is already there. Now, my lord, one document which we have been able to get, my learned friend can verify that document. That is a finance department audit branch memorandum. Just give it to them. Now, they have got it over lunch, my lord. It has some blanks. So I'm cautiously giving it to your lordships. With that caveat, it's been downloaded from their website. But what I just want to show is, just see page 3, clause 8, pensionary benefits is the title.
Yes.
Then come to page 4. Dearness relief up to AICPI average index 536. So the lordship said, is there some document where AICP is mentioned by them? So then this is the result of that research. From their website, we have downloaded. So this is subject to, my lord, Mr. Sibal seeing it and verifying this. So I am very grateful, my lord, for the. Yes.
Thank you, Mr.
I'm grateful. Can I be excused for 10 minutes? Or 15?
Most certainly, most certainly.
May it please your lordship, Lord, I had the privilege to be there before the High Court and the tribunal to argue the matter.
Of course,
Therefore-
we are just neutral, but the lady said that she would be arguing first.
No, Willard, in fact, I ought to
That's all
open the
right.
case.
That's all right.
My
The
lord,
council's
he had made a
requesting
special
you.
request and I said,
Oh,
I have been conceding to the request of others and getting Willard bogged down. Anyway,
we only thought that you would have at the last,
no, Willard, I have to read, Willard, I have been staying here for the last 3 days. Now, the first petition was moved before the tribunal, seeking basically two relief, that our employees posted at Chennai and Bangabhavan, Delhi are getting TA at the central rate. We are not getting it. The government is delaying in payment vis-a-vis the payment time scheduled by the central government, therefore let it be released. And the petition was dismissed by the learned tribunal, holding that DA is only a discretion by the government, you have no right. But from that petition first came before the High Court, that division bench of the High Court decided that no, this is a legally enforceable right. I will not repeat what you have seen that judgment, I should place that part. And so for the other parts concerned, then court directed that following L. Chandra Kumar, those issues should first be decided by the tribunal. Therefore, the tribunal will now decide whether the payment of DA at the rate of central government to a section of the government employees because of their postings at different places would be justified, and whether the non-payment of DA keeping in the time schedule or period released by the central government is justified. Now, the Honorable Tribunal thereafter, in fact, wanted to know from the State Council how they would really interpret their own rules. Now, in the background thereof, I will just invite my kind attention to the rules. If I may please, the rules are not very important.
yes,
Kindly turn to page 126.
yes.
And this 126 is preceded by the recommendation of the Pay Commission, that is at page 97, though it was referred to, I am not taking my leave to refer it once again.
Yes.
Page 97, this is the annexure of the Pay Commission.
Page 90.
7.
Yes.
So kindly come to the paragraph 10.2.
Now we first deal.
Now we first deal with dearness allowance.
Yes.
Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by Pay Commission, so and so, then the state government since 1st April 79, can note this, has been following the same principles followed by the government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably, there is a time lag in actual payment. And when the same is paid, the same does not include any arrears. Right now, only one such installment has remained due, which the government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from March 2009, was sanctioned by the government of India on January 2008. A major grievance of most of the associations of the employees has been
non-payment of the DA installments in time. Now, this is the basic grievance which is still we are pursuing before the court. As per the Government of India's announced policy, this is payable twice a year, namely with effect from 1st January and 1st July each. As per information available, a chart is given. I'm not troubling my lord with that. Then kindly will not turn to 10.6. It is evident from above that a state government sanction of the installment does not follow any definite pattern. It is also clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the Government of India with effect from July 2008. Then fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. It is done, it will mitigate a long-standing grievance. This recommendation of pay commission was accepted.
Yes.
And then the rules were promulgated under 309.
Right.
Now, kindly come to page 162.
Yes.
This is the memorandum dated 23rd February 2009. This is in clarificatory memorandum of the West Bengal Service Rules 2009. 2009 rules that I shall come to your lordship.
Yes.
But kindly now come to next page. After clause 5.
Yes.
To make recommendation each of the clause 5E, to make recommendation each of the above having regard internally to the prevailing pay structure under the central government, public sector undertakings and other state government, etc., the economic conditions of the country, financial responsibility to the Government of India and the pattern of allocation of revenues to the state, the resources of the state government and the demands thereon on account of the commitment of the state government to development activities. The Commission submitted its report on 12 February 2009. After due consideration of the recommendations of the Commission, the Governor has been pleased to make the decisions set out in the following paragraphs. That I emphasize it show that when government appreciated the financial responsibility, having appreciated that, took this recommendation into acceptance and issued rules. Then kindly come to page 166.
Yes.
166 is also very important. This is the continuation of the memorandum, which starts at the very same memorandum, 23rd February 2009, and kindly come to clause 10 at page 166.
Yes.
Consequent upon revision of pay of government employees in accordance with the West Bengal Division of Pay Rules 2009, the dearness allowance to which a government employee is entitled from time to time since the first day of January 2006 needs to be related to pay in the revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated so and so. Then this itself indicates that the government was very much concerned about the payment of DA periodically in terms of or in the pattern followed by the central government. Kindly now come to the rules at 126.
Yes.
By the way, kindly notice the 23rd February 2009 is a very remarkable date. All these notifications are issued on the very same date. That will indicate how the government had appreciated and how the government wanted to implement. Now, this rule at 126, kindly come to page 127.
No, can you just repeat that again?
This 23rd February 2009, when the ROPA Rules 2009 is promulgated, on the very same day, the clarificatory notice comes. The clarification says that I have placed that they have to follow the pattern and they have to fix up in terms of the rules 2009, which is at page 126.
Can you just take us to the notification again?
166. This starts at 162.
The ROPA notification is dated
23rd February 2009.
3rd February 2009.
And this clarification was on 23rd February 2009.
I'm guessing it's page
162.
3rd February. Okay.
And another clarificatory notification is at page 168. There they show the chart how it is to be followed.
Yes. Yes.
Therefore, these three the rules and these memorandums would have to be read together to find out the intention and the decision of the government vis-a-vis payment of dearness allowance.
Yes.
Now, again, I will not come back to page 126 and the relevant portion at page 127.
Yes.
Where Lordship will straightway come to sub-rule C of Rule 3.
Yes.
Existing emoluments mean the aggregate of existing basic pay, dearness pay appropriate to the basic pay, and 4, dearness allowance appropriate to the basic pay.
Yes.
Plus dearness pay at index average 536.
Yes.
Without the base being 1982 equal to 100. Well, this 536 was arrived at by the Consumer Price Index Authority as of December 2005. Why 2005? Because these rules are being effective from January 2006. Therefore, the immediate available data of price index, that was 536, which is the base.
Right.
Subsequently, with the variation, nobody can say that the cost of price index will remain unchanged, unaltered.
Yes.
Then the concept of DA would go. DA is only for the purpose of mitigating the situation of price rise.
Yes.
Therefore, when the rule is given effective from 1st January 2006, the available cost of price index was 536, taking 1982 as the base as 100.
Yes.
Therefore, the basket which was available at the rupees 100 at 1982 is the basis, and on 2006 it is 536 rupees.
Yes.
Now with the change of DA, you have to change it, and that is your own notification. No question of static. 536 is without completely static. It cannot be moved. That is in my humble misconception of the situation and the law. Now, this memorandums will be read together. The High Court finds that this is an enforceable right, which has reached its finality. I'm not going to argue on that. Then the matter is sent back to tribunal. Now, Lordship kindly take the tribunal's order,
Yes.
which is very important. So that is volume 2, page 428.
Yes.
Sorry, but it starts from page 463. But just for Lordship's information, the first division bench judgment which has held that this is enforceable right, but they did not prefer a bill, they preferred a review.
Correct.
The review was dismissed,
Correct.
and then they went back to the tribunal accepting the judgment, filed their affidavit, and contested on merit whether we are entitled to the DA at the same cycle and rate by the central government or not.
Very good.
Here, Lordship kindly turn to
No, cycle board is not mentioned.
my lord,
Cycle board is not mentioned
No,
in the
no,
High Court remand order.
not
It is only rate which is mentioned.
Milord, the remand Milord is only Milord sending back the original application.
And this,
Remand,
there was no cycle prayer.
no,
In your original application preferred before the tribunal at the inception.
Milord, my prayer was because the original application that release at the same rate.
Rate, not cycle.
Same rate means Milord, yes, same. No, kindly comes Milord, my prayer is also, if your
Yes.
lordship takes up my prayer B,
Come. High Court,
258. The High Court,
remand order, High Court has noted.
No, High Court has only sent back the matter.
368,
368, yes,
368.
my lord. This is the division bench judgment.
Yes.
No, my lord, before my lord lordship.
Just
368, that is reproduced.
May also leave.
Okay.
Please show that what is up. Want the of the people. Not person. Please upload all. Then, we have a practice here that our orders must be uploaded within 24 hours. That's a practice which this court follows.
Oh, that's wonderful.
Every order has to be uploaded within 24 hours. Therefore, we are telling his leave and upload it.
Wonderful. That's really.
Because agree, this
Very
court order is
beneficial.
uploaded.
This is
within 24 hours.
helpful for all of us. Now, kindly takes the trouble to come to prayers quoted in the.
She's reluctant because it's not the norm here. that she should leave the court.
At page 369, kindly see whether the original application prayers reported. 369. This is the first division bench judgment which has.
No, we were quite doubtful. In fact, we put it to Mr. Patwalia, but couldn't get the answer. If the High Court had decided everything,
No.
that's not valid. That's how I read. We may have committed a mistake.
Sorry.
In reading it. If the High Court had decided everything, then what was the occasion for the High Court to remand the matter, and more so, para 84? And that's what is for.
Well, may I just tell your lordship why High Court remanded it?
We only want to know page, what is the import of para.
I will take a lordship. I will take a lordship. The kindly sees below my prayer which was there in original application.
Continue. Sorry, we didn't
No,
want to.
para 2, a direction upon the responding authorities. Para, that's at page 369. 369.
Since it is your baby, we thought, you are the best person to answer.
Yes, that's true.
Yes.
But a direction upon the respondents' authorities to forthwith release the 50% DNS allowance which was due up to January 2006 immediately. That is inherent. And then a direction upon the respondent to immediately comply with the report and recommendation of the Fifth Pay Commission positively and without fail within a period of 1 month from the communication. But the Fifth Pay Commission says that, and when I say that pay 50% of the allowance which is due, that comes due vis-a-vis, then direction of respondents to release the 50% of DNS allowance as the state government without releasing the 50% DNS allowance for mere eyewash. Set up a sixth pay commission is not important, my lord. Therefore, these were the prayers. What the division bench has done after having coming to the conclusion that this is not only a discretion of the state, this is an enforceable right. Then kindly come to the why the High Court remanded it. Kindly come to the page 82.
Yes.
No, before that, may I just take the other part? Kindly come to the page 391.
Yes.
Paragraph 76. Oh, sorry, Willard, I probably have missed. Willard, yes. Paragraph 52.
Paragraph 52.
Sorry, 52, 385. After considering, I got it.
Yes.
After considering the above report of ROPA 2009 was framed in exercise of power conferred by the so-and-so, therefore it is evident that the DNS allowance was also one of the components which came under the purview of its considering the rolling out of Fifth Pay Commission. Subrule 1 of Rule 12 of ROPA provided that no arrears of pay which government employee might be entitled in respect to the period from January 6 to March 2008, that this is the reflection of government's consideration of financial liability. Therefore, they said that this part you are not getting should be paid to the government employees. Needless to point out that the above decision included non-payment of arrear DNS allowance for the period. The government of West Bengal Finance Department Audit Branch that I have placed this, I am not troubling my lord it again. Then kindly come to paragraph 59, which Mr. Patwali has placed. I am not taking troubling my lord with that.
Yes.
Then kindly come to 68.
Yes.
Under sub-rule 1 of Rule 12 of the ROPA, it was declared that no arrears of pay to which government employee might be entitled in respect of so and so. I have already found that paragraph 10 of the clarificatory memorandum, February 23rd, 2009, and on allied matters provided that the DNS allowance to which the employee serving under the government of West Bengal was entitled from time to time. That this rules out the perception of stagnancy.
Correct.
1st of January needed to be related to pay in revised pay structure in this regard. This was the finding. Then 76.
Yes.
Further, the factors which were taken into consideration by the central government in fixing the rate of DNS allowance for its employees were required to be taken into consideration with those taken into consideration by the government of West Bengal. In the event the factors were common and same for both governments, then the element of arbitrariness were required to be examined in the context. These are all on the basis then why it was remanded. We kindly come to Milord paragraph 82.
Yes.
The claim of the employees serving under the government of West Bengal is based on legally enforceable right on all the employees serving under the government of West Bengal up to such extent recommendation of Fifth Pay Commission, which has been accepted by the government by ROPA rules. Then finance department so and so. The claim of the employees serving under the government of West Bengal to get DNS allowance at a rate equivalent to that of the employees of the central government requires adjudication upon consideration of the relevant materials on record for the purpose indicated here and above. The claim of the employees serving under the government of West Bengal for DNS allowance at a rate equivalent to that of the employees discharging their function in Bongo Bhavan at New Delhi and Youth Hostel in Chennai requires consideration of the materials which may be brought on record by the government of West Bengal. The aforesaid second and third issues, namely whether the claim of the employees serving under the government of West Bengal for DNS allowance at a rate equivalent to that of the employees central government, whether the discrimination in the matter payment of DNS allowance at the employees of state of West Bengal so and so, then court cannot be done in this seat application. As a court of first instance, in view of the principles of law settled in the matter of L. Chandrakumar, the learned tribunal is the appropriate forum to discharge the above function as a court of first instance. That's why it was demanded that only the issue which was decided by the tribunal rejecting the OA, holding that you are not entitled to, that issue was not considered, others issue was not considered by the High Court and said, go before the tribunal and get it decided. Therefore, the High Court had no more occasion to go into the other issues because those issues were not then yet decided by the tribunal. To the final judgment of the tribunal.
Yes.
Which has been was taken to the High Court, or the High Court refused it, refused it.
Yes.
Then now it's before Lordship. Now kindly turn to the paragraph 28. Since the other issues which have been dealt with here have been repeatedly argued, I am just avoiding.
Yes.
I am straightway coming to paragraph 28.
Yes.
Since we have to examine whether the employees serving under the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government, we need to first understand what are the issues and processes involved in payment of DA to the government employees. And the memorandum issued for payment of DA and revision of DA, February 23rd, 2009, which I have only placed before Lordship, we find the following similarities and differences in payment of DA to the state government employees as compared to the central government employees. DA has been paid as a percentage of the basic pay, not on the full package for both central government employees and the state government employees. Both the central government in terms of 6th Central Pay Commission and the state government in terms of 5th Pay Commission have used AICPI 1982 being 100 for industrial workers for measurement of inflation. This is very important. When the AICPI does not determine the DA, it determines the inflation on the basis of which the DA has to be determined by the respective governments. Therefore, AICPI is the basic norm. The base AICPI for calculation of DA with effect from January 2006, when DA has been considered as zero, has been the AICPI of 536 as per 1982 series, which has been same for the central government employees under 6th Pay Commission and the state government employees under 5th Pay Commission. In fixing the initial basic pay in the revised pay structure, as on January 1, 2006, the same AICPI has been used by both center and the state.
Continue.
Yes. Then in case of central government employees, it has been specifically mentioned in the notification that the inflation neutralization will be 100%, meaning thereby.
Continue, sir. Yes, just.
Yes,
Here with you.
Now will be 100%, meaning thereby the DA percentage increase will be same as the percentage increase in the ICPI. But this is the finding of the tribunal itself. In case the state government employees, it has not been specifically mentioned that inflation neutralization will be 100%, but the pattern of payment of DA in the initial years till 2010 indicates that the state government has also followed the same principle. Therefore, up to 2010, when the state government followed the central government method blindly. 2011, with the change of dispensation, all these variations comes into operation. Now, it has been notified by the central government while accepting the recommendation of 6th Pay Commission that DA will be sanctioned twice in a year, January and July. This has not been clearly spelled out by the state government by any notification. Though on scrutiny of notifications, we find that while in the initial years till 2010, payment of DA was made twice in a year. But after 2010, the state government has not followed this pattern. The practice of revision of DA on January and July is done by the central government. The central government has notified that the revised DA on January and July will be payable with the salary of March and September respectively. This timely payment of DA has guaranteed compensation. We'll kindly underline these things, which is very important for the purpose of fixing DA. Guaranteed compensation for erosion of basic salary within a reasonable period of time. In case of the state government, there is no such notification and no such principles have been followed, and there has been a long delay in protecting the erosion. This is the basic consideration. Now, comparison of payment of DA by the central government to its employees and by the state government to its employees, we find that the principles followed by the state government in terms of relationship between DA and the basic pay, use of AICPI as a measure of inflation, relationship between DA and ICPI and computation of DA are the same as that of the central government.
Yes.
The state government has followed the same principle for computation and payment of DA on basic pay fixed under 5th State Pay Commission, as has been done by the Central 6th Pay Commission. The Central has revised DA twice in a year, January and July, on which DA is payable, where the state government initially paid twice in a year, but discontinued to pay twice in a year after the year 2010, and has delayed payments of DA without following any principle in an arbitrary manner.
Yes.
Therefore, that this delay of release, if that is taken care of, I think the demands of the employees will be met. This is the grievance which the tribunal finds this is arbitrary.
Yes.
Division bench of the High Court has observed that DNS allowance is a legally enforceable right of the state government employees, which means that the state government employees have the right to be compensated for the erosion of their basic salary due to inflation. If the real value of basic pay decreases due to inflation, then the state government employees have the right to be compensated. And if such compensation is not given effect within a period of reasonable time, then their right to get compensated is infringed. Inflation changes with time, and thus the period of time within which the employees are to be compensated is extremely important. And as such, the right to get DA within reasonable period of time is an integral part of legally enforceable right.
Did not read
This, sir.
we have on now kindly come to page para 33.
Well, yes, I was going to show that
33.
31, Lordship probably had noticed. Kindly,
Exactly, para 33. And that's what everyone has read, both the sides have read.
yes, we have read 33. I am at 33. We have already observed that there is no mandate either under the statutory rule, namely ROPA 2009, or in the administrative directions issued by the state government in the form of memorandum, dated so and so, which I placed before Lordship. Now, in the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussions made by us here in About, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published. It is a bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of ROPA 2009.
We request you to please focus on this. First, also Mr. Patwali has said how AICPI is applicable. Would you like to add something more to that? Is what we are asking.
No, I would not be adding a lot to burden the Honorable Court time and without patience. What I'm saying,
We are very patient.
no, I feel that.
We have
But as a counsel, it's my duty to feel also what.
But what we are saying,
Therefore,
core issue,
yes, core issue.
whether AICPI is applicable or not, this is a core issue.
No, it's applicable, no doubt.
What is the finding of the tribunal? What is the finding of the High Court? Is what we have to now consider. So therefore, apart from, in addition to what the courts have read and what has been argued, is there anything else which you wish?
No, Lord, at the moment, Lord, I have nothing to say except that kindly come to 34. It's very important.
34. Yes. Let's see.
Let us say the don't. Now kindly come to 34. Next issue. For our consideration, whether the payment of DA to the employees of state government at Bangabhavan, in New Delhi and the youth hostel in Chennai at the rate payable to the employees of central government and payment of DA to other state government employees working within the state of West Bengal at a different rate is discriminatory. The admitted position is that the state government employees working at Bangabhavan.
But Mr. Diwan said that he is not challenging.
So, therefore, the fact remains, Lord, today after this order, they say we have accepted this. The fact remains, Lord, so far the DA is concerned to the state government employees, some was getting at this central level. Therefore, you do not dispute and deny, I am on that.
Oh.
That the payment of DA at the central method
Yes.
was acceptable to you.
Correct.
And that's why you have paid to some of the employees.
Yes.
Now you have to, the tribunal says that there is no statutory mandate, but at the same time, tribunal says you have to evolve the method.
Yes.
Evolve the method for payment so that there is no erosion of the issue of payment of GNS allowance. But today price rise is indexed, it is rising. Now I am paid 2 years thereafter. In the meantime, further price rise. How would the employee cope up with that? Therefore, you are in fact frustrating the basic purpose of DA.
Well,
these are the basic things on which I would like to emphasize upon. Therefore, the question of applicability of the AICPI is not under doubt. And the change of the pattern of payment up to 2010, the government followed the same. If the government did not have any doubt that this should be followed. 2011 after, you have departed by not paying on time. Therefore, the payment of DA is not under dispute. The dispute is payment on time. Now, as I said, when you accept the Pay Commission's recommendation, you accept with the financial responsibility and liability. You know this. That's why you say you did not pay me the arrear from 2006 to 2008. That is a part of conditional acceptance of the recommendation. Therefore, subsequent to that too, You know that this is my financial liability. Now, you cannot just turn around and say, no, no, I don't have any finance. But though the finance is not there or not, but that is, they have the difference in the content petition before the High Court. The High Court must decide whether genuinely they have any difficulty or not. Now, the question of the finance, I just rely on one judgment and then let's stop. This is not 2022, Volume 4 Supreme Court cases, page 363.
So cognitive financial difficulty cannot be an estoppel.
Yes. Paragraph 57 particularly.
Yeah.
Therefore, the defense of the state below the argument which was sought to be developed as a new argument, it was never argued before the tribunal or before the High Court. And the idea that DA Millard gets stagnated on 536 to deepest of respect is totally Millard creation out of blue without having any foundation. My juniors do not insist me to believe
Even according to them, it is not static. It is swinging, but not the way you want it to.
No, that obviously is other difference. If they accept the way I want, there is no question of the litigation. But no, they have to be reasonable. If they say, I do not accept you 100%, I have a reasonable way of doing it. State will not, in no way can not. Paragraph 38 at page 482. Yes.
Paragraph 38.
Well, kindly come to us. Yes, I had also marked it, but slipped it. I'm reading out for what norms or principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, the learned counsel representing the state.
Yes.
Mr. Basu merely tried to impress upon us that state government has following the pattern of the central government have admitted. Following the pattern of central government releasing DA to its employees, but the state government could not pay DA.
Which page you are in?
Look, page 482, paragraph 30 of the plan. That's judgment.
We thought you are reading this judgment which you have.
No. After without placing the judgment, juniors are prompting me that.
38 you are reading this. The function of the pleading is.
Paragraph 30, page 482.
We have read it. Don't worry.
That was read, then it was read. So that's all. But that I hope not your lordship will read these two.
Next.
Yes, please. May I take deep?
Most certainly. In the one voyage.
I was stuck up here for the last 3 days.
My lords, today, after Mandawar, we have the Constitution of India. And under Article 309, the requirement is for the rules to contain the schema to calculate employment terms, for everything to flow from the rules. And why is this, my lords? This is because the Constitution is the bulwark of state government employees, central government employees, industrial employees against arbitrariness.
Yes.
So therefore, my lords, the ambit of the disagreement between us is what do those rules mean? When they cite the All India Consumer Price Index, what do they mean? My lord, my learned senior Mr. Subramaniam has been kind enough to give me this report. Which we will hand over. It's the annual report, my lords, of 2010, issued by the Ministry of Labour and Employment on the Consumer Price Index. My lords have it.
Yes. I could not comprehend your submission. That after Mandela we have the constitution. I somehow missed it out.
My lords, Mandava referred to a set of fundamental rules that was pre-constitutional.
But nonetheless, constitution was there and anyhow, either okay.
My lords, I will also come to Mandava and satisfy my lords. Essentially, very briefly, the rule in Mandava, my lords, Rule 44 of the fundamental rules, is the rule that granted discretion to the state governments. Now, our rule, what it does is that pursuant to the discretion, it records a commitment by the state government to follow 536 brackets 1982.
So you may
Beginning at
Mandava may or may not apply, but Mandava was anyhow, that's all right, we understood what it is. Yes.
I'll also come to Mandava, my lords, and attempt to satisfy. My lords have the folded portion in the report.
Yes.
Page 3, which is the preface, it says, the consumer price index numbers for industrial workers are being compiled, maintained, and disseminated by the Labour Bureau since its inception in October 1946. These index numbers, apart from being utilized for fixation and revision of wages, determination of variable diurnus allowances, and this is important, my lords, that this is a prime reason why this is compiled in the first place.
Yes.
Are also utilized as an indicator for measuring inflationary trend in the country and for policy formulations. These index numbers are compiled by the Bureau on month-to-month basis and are disseminated through press release, monthly index letters, Indian Labour Journal and website. Despite regular dissemination of these index numbers through various forms of media, there has been a growing demand over the years from users for more detailed serial data vis-a-vis what is, I beg your pardon.
Yes, yes.
What is published through the ILJ and other publications of the Bureau. Labour Bureau, accordingly, for the first time in 1997, brought out an annual report on consumer price index numbers for industrial workers, containing details of all India and center-wise indices for the year 1996, which was well appreciated by the users. Now, my lords, they then thank shopkeepers, but what I want to point out is that I take this opportunity to express my gratitude to all the selected shopkeepers of the selected markets in 78 selected centers who are furnishing price data on voluntary basis. Now, my lords, these 78 centers will include rural Uttar Pradesh, rural West Bengal, Calcutta, Park Street, it's expensive even for me sometimes, my lords, South Delhi, other parts of Delhi that are less expensive, Bongo Bhavan is in Delhi, Chennai, which has variable rates in terms of prices depending on locality. But this, my lords, is the all India index. So, my lords, why would the state of West Bengal adopt an all India index? And that is because
Yes, continue.
yes, my lords, I'm just coming to the point at which they explain that the earlier.
Just one minute.
Will my lords be kind enough to come to page 34 of this report? This is not the folded part, this is now the next one.
Yes.
My lords have it?
The Indian scenario?
My lords, yes, I'm on para 4.2, which is the second paragraph.
Correct. The compilation of index numbers.
The compilation of index numbers in the country dates back to the period immediately following the First World War. The sharp rise in the prices focused the attention of several provincial governments on the problem of rising cost of living. As a result, some provincial governments started conducting family budget inquiries and compilation of consumer price index numbers for some cities in the country. As none of these index numbers were satisfactory, the job of compilation of consumer price index numbers was entrusted to the Labour Bureau. This is the one in Simla, earlier known as the Cost of Living Directorate, on the recommendations made by the Rao Court of Inquiry in 1943. The Labour Bureau launched Family Living Survey during 1958 to 59 in 50 important industrial centres all over the country on uniform and scientific lines laid down by the Technical Advisory Committee on Cost of Living Index numbers. Based on the results of the survey and utilizing the retail prices regularly collected from the selected markets, the Consumer Price Index numbers for industrial workers on base 1960 for each of the 50 centres in all India had been compiled and published by the Labour Bureau. Amongst all the available CPI series compiled at the national level, the CPI series for the industrial workers is the most popular, as also talked about series, as the dearness allowance of the industrial workers, as also of all salaried employees in public and private sectors, in services and trade, etc., is regulated on the basis of average all India centre-specific CPI series for industrial workers. Even central pay commissions in the past used CPI for industrial workers than the CPI series for urban non-manual employees, for regulation of salaries and allowance of central government employees, including public sector employees and the armed forces.
Yes.
Now, my lords, I'll just point out for my lord's satisfaction that in the folded portion, page 15,
Yes.
in the first column, 2005, it mentions our 536, which was adopted in the rules, in the ROPA rules.
Yes.
And my lords, this was the reason I began with this was that it had fallen from my lords that where does the how does the index connect to dearness allowance? And the main purpose for which the index is compiled based on that basket of goods that the average working family uses is to calculate dearness allowance.
Okay.
Now, my lords, the calculation of dearness allowance, and I won't go into the formula which my learned friends before me have placed, but the formula is quite clear that you use the base AICPI and then you use the current inflation rate. And based on the two, then you come up with a number. Now, if you have the base CPI, there is nothing from them to say how their 2%, 6%, 16%, 125%, how it's calculated. And my lords, the only way in which you can use this base number is by using a number that is an all India number based on the same basket of goods. Because otherwise it would be meaningless. So there are, for example, other states that have not adopted the AICPI. For example, we have the state of Kerala. So what does the state of Kerala do? And this is in my compilation. Okay.
Yes.
My lords, at page 83, It's page 80, I beg your pardon.
Yes.
This is the Kerala Department of Economics and Statistics, the consumer price index number for agricultural laborers and industrial workers for the month of April 2025.
Okay.
Video so dated 31st August 2013 of the Labour and Skills Department, Government of Kerala, and the MS or government order dated 2015, published in the Kerala Gazette. They have, my lords, these various centers, and they have compiled their own
Yes.
consumer price index
Yes.
based on 17 centers.
Okay.
So they don't make reference to the AICPI. They use their own. No problem. Because under Article 309, all it says
Can you just read page 80 again?
yes, please. My lord, Mr. have page 80. So, my lords, this is from the Department of Economics and Statistics of the Government of Kerala.
Something about government of Kerala.
This is the Government of Kerala, my lord. My lords, I'm just giving an example of another state that does not wish to use the AICPI.
We are not, Kerala is also not using AICPI.
Kerala is not using AICPI, my lords. West Bengal is using AICPI in their rules, but not in practice. Kerala, my lords, has disavowed AICPI because what they have done is that they have evolved their own mechanism, and they have 17 centers from which they determine their own Kerala Consumer Price Index for agricultural laborers and industrial workers. So they don't have rules where they reference the central government.
Is there any such price index specific for West Bengal?
I beg your pardon, my lord.
Is there any specific price index which is specific to West Bengal, like
My
in
lords,
Kerala?
I appreciate what has fallen from my lords. There is not.
Yes.
So, my lords, therefore, we have a situation where Mr. Divan's argument, brilliant though it is,
Mr. Subramaniam. Where do we find that which index, like if Kerala is using such state specific index, so where is that enabling provision as to which index will be used, whether state specific index or AICPI, or you may choose whatever you like.
Well, actually, what one does is that AICPI is a very reliable form of gauging inflation.
No,
Because, well, I'll tell you,
we are not about reliability.
yes.
Where is the legal sanction or absence of sanction for use of a particular index?
Well, the legal sanction.
Yes.
Yeah.
If they are using
it's in the rule.
their own index, something like,
Yes.
or if they are not adhering to AICPI, they must be calculating on the basis of some index, because rule says average index.
Well, that's the perfect.
What
perfect.
is that?
Yeah, well, no, I'm grateful. That's the perfect question your lordships asked.
Is
What is that index which
Yes,
you have used?
which they are using.
That's the point. Well, there is no index apart from this. There is nothing like a.
That was the question asked.
As I said, well, there's nothing like a Mahalanobis formula. That's why they've not done that. That is the whole point.
And they have
So, in the absence of Malone, any specific index specific to West Bengal, which has been formulated by them through rational criteria or through any scientific study, they are relying only on this AICPI, that is 536.
536 is the pointer.
536 is the point.
They are not adhering to it.
They are
And they are not
adhering.
adhering.
That's the point.
And therefore it is arbitrary.
Therefore, it is arbitrary.
or
Whimsical and
based
capricious.
on women fancy.
And
Yes,
that is
my
right. That is the point.
That is
Crux of the-
precisely the point, my lord.
The burden of.
So, my lords, therefore, grateful for the question, my lords. Because, my lords, the constitution gives them discretion. They could have devised a consumer price index of their own. They could have gone to Purulia, 24 Parganas, Kolkata, and devised a consumer price index of their own. They did not.
Point well taken.
My lords, while I was just making the point that had we've all been working very hard in the last 2 days. And the reason, my lords, is that the argument came up for the first time.
We have no doubt about
Yes.
whatever you would have put in the matter. We have no doubt, I'm saying.
So
We are saying we have no doubt.
But my lords, the argument came up for the first time that it is a static figure. It has come after 20 years, after 6 courts and tribunals have held in my favor. Every time we won, a review was filed. We would win the review, then they would go up, then they would go down, then we would, and every single time, my lords, we succeeded. I won't repeat what has come before me, which is in terms of the arguments that were made in the courts below. Not once did they say that this AICPI figure is static. They said it's an ad hoc basis.
Taken here for the first time.
Yes, ma'am.
Yes.
And my lords, it's a factual argument. It's not a legal argument. My lords, if I may now come to the fact that
Anything which you wish to add to what has already been, committed.
yes, my lords, I'm not going to repeat. My lords will appreciate that the Royappa judgment is a guard against arbitrariness.
Yes. How would Royappa apply?
My lords, because it's a guard against arbitrariness in public
Obviously.
employment.
The set of intention of yours, it's arbitrary, then it goes without saying, it will apply.
Yes. My lords, if I may come to the fact that the employees of the West Bengal State Electricity Transmission Commission are getting a rate that is equivalent to the central government rate. Now, if I may come to, this is paper book 35 of
In fact, this key was taken before CAT.
yes, my lords.
It was taken.
But I would like to refresh our collective memory on it, my lords. Reason being that there is also a decision of this court, and that judgment has attained finality.
Yes.
So, my Lord Justice Mishra had said that there are different categories of employees that are getting different rates. So, we had 3 categories so far. We had the employees at Bongo Bhavan
Bengal and Bengal.
and West Bengal. But there is a further subcategory in West Bengal. So, first, if I may come to, this is paper book 35 of my counter, my lord.
Yes.
Respondent number 2.
Yes.
This is where it begins. And so they examined whether power companies could depart from the mandate to pay dearness allowance as central government rates on the grounds of financial hardship. My lords have the Supreme Court order, I think.
Yes.
So we can go to that first, my lord. Says in the facts and circumstances of the case, and more particularly, considering the fact that even till January 2016,
Yes.
respective employees were paid the journalist allowance at the central government rates. Has it been allowed or notice installation? My lords, I am told that notice has been issued on a review, but we also have a number of judgments after Sabrimala, which is also in review, that this can be relied on.
Then you see, it is a matter of view, matters are not.
Fair enough. But currently,
Yes.
but my lords, currently, as we speak,
Yes.
there are now admittedly, four categories. And they are all, three are getting paid at the AICPI rate.
Yes.
I, for no good reason and no explicable reason, I'm getting paid at the rate that they decide whimsically from time to time,
Yes.
with no basis, no material on record, and it then flies in the face of the government, the judgments of this court from time to time.
Yes.
My lords, I also wanted to place the fact
Yes.
that my lords have never hesitated to bring reasonableness into a government scheme
Yes.
that has been arbitrary in this regard.
No, but can we legislate what our query to you? You say that it has to be, we have to bring in reasonableness.
My lords, if I may point out what, my lords, this would not be akin to legislation. The reason being that due to the fact that the rules require a schema to be placed within the rules, and the rules do have a schema according to us, that anything concomitant to that to give effect to that statute is something that my lords will do, and that is the intention that will be read in.
Very.
And my lords, the intention may be read in from the fact that that particular rule is close to identical to the central rule.
So, which is this citation?
So this citation, my lords, is this is Kamani Metals versus Workmen.
Money was there in the file.
My lords, the book actually has a slightly different version, which is why we've given it to the Madam Court Master.
Oh, really? Give us the citation.
1967, 2 SCR. My lords, the electronic version is a little bit different. 1967.
The money, not quantity is out that you are given it, but she says that it's a different version.
Very good.
So the money is referred in this Bengal chemical.
Yes.
It's referred in Bengal Chemicals, but I want
There are
to point
21
out.
Bengal chemicals, it is referred.
It is absolutely, my lords.
Uh-huh.
But my lords, I wanted to point out something slightly different, which is only in the
Citations.
1967, volume 2 SCR, page number 463.
Yes.
At page 474.
Yes.
Now, my lords had said that there is a hesitation to legislate. That is absolutely not what we are seeing. What we are saying is that they have already legislated. And what we are seeking is that my lords give effect to that. So what they did in Kamani, my lords, is, do my lords have it?
Yes. No, because you invoke the principle of reasonableness.
Of reasonableness.
Can we legislate or not? It is only in that background.
So, my lords, I'm invoking Article 14 reason
Please. Okay.
and non-arbitrariness.
Okay.
So, my lords, page 474.
Yes.
It says this brings us to the last question, which is related to the dearness allowance payable to the monthly rated workmen. Previous to the present award, and this is the award by the tribunal, The dearness allowance was payable in this company in the following manner. So then they put out the slabs on the first ₹100 up to ₹100, and this is the full salary. They say 60% with the minimum of the DA paid to the textile operatives by the Bombay Mill Owners Association. And then they put out various slabs up to ₹200, 300, 400, 500. This is what they had previously. The above percentage of dearness allowance is applicable when the Bombay cost of living index rests between 311 to 320. Variation in the above percentage to be allowed for 10-point movement in the index. First slab, 3% of dearness allowance, second slab so and so, fourth slab, third, fourth slab so and so. In the award, this has been altered to a scheme which is as follows. On the first ₹100, they change it to basic pay. My lords change it to basic pay instead of being the full salary. And then it is said that this is 60% on the second ₹100 basic pay up to 35%, etc. So this is the alteration that is done by my lords in Kamani. In Bengal Chemicals, my lords have also made clear that a sliding scale is to be read in when it's not there. That one can't just say that this fixed amount is to be given in terms of dearness allowance. That a sliding scale is then read in. My lords, I'll also hand over in my written submissions that I will amend based on what my lords have asked. A judgment in Ajay Kumar Das, where they say that memoranda can never override a regulation. And similarly, my lords, that is at, I'll give the citation.
Yes.
Similarly, my lords, in Ashok Ram versus the state of Maharashtra.
Yes.
My lords, in the Bank of Baroda versus G. Palani, 2025 S614. Vested rights of employees were protected, and it was the supplanting of established legal frameworks with arbitrary governmental decisions was resisted. If I may read this, lords, I'll also put it in a note. The Honorable Court's judgment citing with approval the precedent set in K.
Much more
Swami.
time.
My lords, another 5-6 minutes.
Then we can finish today.
Yes, sir.
You have only 3 minutes today.
We can finish.
No, wait, no. So if you wish, we can continue tomorrow. There's no.
I'll be grateful, my lords. Tomorrow I won't take more than 10 minutes.
Tomorrow also 5-6 minutes.
Okay.
I'll take 3 after that.
Fair enough.
I'll take 3 just to sum up, nothing.
We told you.
After the leaves.
What we do is that, can we do one thing? Can we just return your compilation
Yes,
so that, tomorrow give us a comprehensive.
will do.
What's it? Yes.
Recompilation is. एक फोल्डर में डाल के निकाल दें।
Tomorrow we expect in the morning session this to be over. We request because we are just now informed that no, they would take about another 10 minutes. So this side another 10 more minutes.
Not more than 10.
Both of you. And then we expect.
Yes.
Because we have, at 1 o'clock, 2 o'clock, we have another.
No, we are at your lodge.
Another bench.
We will be at your lodge.
Thank you.
Grateful.
You want-
So grateful.
Lordship, in item 15, I represent the respondent. We kindly request that the matter be listed tomorrow or on a date in the next week.
पहले आदमी आती ना ऑनलाइन जो पासवर्ड किया था 15 नंबर आफ्टर नोटिस में वर्ष वो आफ्टर नोटिस आना तो उसमें टाइम
Yeah.
Right.